Hello, everybody. Hello, C-Rex. Hello, Nana Laura. Oh my goodness. I am so glad that they tested that. That's terrifying. Well, I hope they can get that sorted out. She's still in my prayers, for sure. Hi, Ava. Welcome. Welcome, baby girl. I had them ready. I had them ready. Oop, oop. I guess you're gonna have to get that one, baby girl. It's like the fries in the bottom of the bag treat, only this is, treat on the bottom of the floor. Yeah. Go, there it is. Go, get it. Yep. It's a bonus. It's a bonus treat. Hi, Tiny Kitten. Tiny Kitten Esquire coming early. Hello, Catherine Gaston. Yeah, protein's definitely a good idea. And cheddar cheese. Cheddar cheese, I have heard. My mom swore by it when her blood sugar was wonky. She always said to do cheddar cheese. My allergies are killing me, so I'm taking a Benadryl booster. Oh, I moved them so you can swipe them off the desk. Yeah, oh, look at you with your energy back. Mm-hmm. Hello, isn't that special? She seems to be feeling all right. She's jumping up here. That's a bonus. Hello, Tiny Kitten Tail. Tiny Kitten Esquire. So, we got a bunch of good stuff tonight. I got Licking County, Ohio, special for Joey Bag of Donuts. I was hoping he'd see the thumbnail and be here, but he's probably driving. I'd rather he drive safe. But we're gonna get right into it. We don't have a giant crew tonight yet. Hoping everybody will see that I'm on. I know it's super uber early. I figured you would. I remember. Yeah, baby girl. That was 3 plus 1. I know. Yeah. I know. You can only count to 3. And then I throw in that bonus one and you get all confused. I'm hoping to be able to continue with the earlier ones, and I'm definitely really hoping that that more people will see and be able to attend since it is earlier. Fantastic. Glad to have you. You know that. All right, guys. Let's get into it. Let's see. What did I name this one? Hold on. What did I name this one? Where did it go? Oh, oh my gosh, did I not export it? I never hit export. Oh, I'm doing fantastic. Oh, give me just one moment. I am rocking it today. Oh my goodness. I was so excited that I had everything done that I didn't export it. Good thing I have my new computer, and a 2-hour and 12-minute docket is not going to take 2 hours to export. Oh, I'm so good at this. That's all right. I got something in the mail. It's okay. So that is coffee mugs. This one says handle with care and fragile. So I'm thinking, but it's addressed to the night shift of April. So I'm thinking it's more merch. I'm thinking it's maybe more coffee mugs, but wow, that would be a lot of coffee mugs that I ordered. Oh wow! These come in their own individual little boxes. Oh, I'm so curious now. I'm so curious now. Did I get them from another company? I mean, they do that sometimes. Oh, wow. Cool. So rather than being encased in styrofoam like the last batch, these ones, they come like protected in the cardboard. Okay, so I now have, oh, come on. They've styrofoamed them and taped them. At least it's, peelable styrofoam. But the problem is it's peelable styrofoam. Yay! So these are the drunk man's words or sober man's thoughts ones. Among others, of course. But this is the oh my gosh, I love them. Yep, and it's on both sides, so it's whether you're left-handed or right-handed. Oh, that's so exciting. Oh, I'm so happy about that. That is so neat. So we now have more coffee mugs for merch. And they come in these nifty boxes to top it off. Yeah, look at that. That's so cool. That is so cool. I love it. I'm amused by the simplest things. I love it. The other one didn't have a fragile sticker on it. Fragile. Oh, that was not a. Ooh, that was not smart of me. That was not smart. I have kitty treats on my floor. Oh, I took you guys' advice, and I got CBD calming chews for cats and dogs. Yes, yes. So yeah, so now I gave them to him today. They I don't notice yet. Ava, get out from under there. Please. No, fully. My goodness. Okay, guys, now I have the cases exported. It was just, giving people an opportunity to get in here, and four more people showed up. So, it was worth it. Oh, I'm such a putz. Let's see here. There it is.
All right, we're on the record now in case number 25 CVF 00391. It's captioned All-Star Motor Sales versus Cynthia is it Trufant?
Trufant.
All right. The record should reflect the defendants here. Counsel, you want to go ahead and make an appearance on behalf of the plaintiff?
Sure. My name is Michael Lubes, L-U-B-E-S, on behalf of Plaintiff All-Star Motor Sales. I'm the number 2 guy on the signature block.
It is not lost upon me that the attorney for the car dealership is Mr. Lubes.
Okay. And Mr. Lubes, is the plaintiff ready to proceed on your claim?
We are, Your Honor.
And Ms. Trufant, are you ready to have your trial today?
Yeah.
Okay, very well. Please call your first witness.
Your Honor, it's an introductory thing. I gave the bailiff a bench copy of our exhibit so that we can all track through.
Very good.
Sir, could you state your name and spell your last name?
We're going to have him. You call your witness.
Okay, I call John Campbell.
Mr. Campbell, please come forward and be sworn.
Okay, here, take these with you.
Do you solemnly swear or do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury? Please have a seat. For the record, you're going to give your name and spell your last name.
My name is Jonathan Campbell, C-A-M-P-B-E-L-L,
And the address of your employer.
250 North 21st Street, Newark, Ohio, 43055.
Thank you, sir.
Thank you. You may inquire.
All right, and Mr. Campbell, for whom are you employed?
All-Star Motor Sales,
And what's your position there?
I'm the owner.
All right, and in your job title or job activities in relation to being an owner, are you responsible for the documents that are prepared and generated in the business of what you do?
Yes,
All right, so these documents, are they made in the ordinary course of business, or are they made in lieu of litigation?
ordinary business.
Okay, and you're the one that teaches staff and monitors all the documents that go into a file, is that correct?
I am, yes.
Okay. I'm going to go through a bunch of documents that we've listed. Let's start with what's labeled as Exhibit 1. Do you have that in front of you?
I do, yes.
What's the caption of that document? What it's
A
called?
retail installment contract,
Okay, and could you tell the court the date of that contract?
contract date is 4/27 of 24.
Okay, and who is the buyer listed on that contract?
Cynthia Trufant,
Okay, and who is the seller on the contract?
All-Star Motor Sales, LLC.
And I know we talked about it, but that's right here in Newark.
Correct,
in Licking
yes.
County, okay? And this contract was helped to facilitate a vehicle, is that correct?
Correct.
And if you look at this, can you give us the year, make, and model of that vehicle?
So 2013 Mazda CX-9,
And just for brevity's sake, could you give us the last 6 of the VIN for us, please?
404585.
And that mileage, does that represent the mileage that was on the car when this contract was entered into?
It does.
And could you just read that off for the court, please?
201359.
All right, moving down to what's called the Federal Truth in Lending Disclosures. Can you tell us what the annual percentage rate was on this loan?
23.99.
And moving to the middle box, what was the amount financed?
$9,207.30.
All right, moving over to the far right box, can you tell us how much the down payment was?
$1,000.
Okay, and then below that tells you the terms of payment, when it was due, etc. Is that correct?
Correct, yes.
All right, and these signatures that are applied there where it says buyer, do you know, or do you have reason to know who was the person that affixed with those signatures?
I'm going to say Cynthia Trufant.
Okay.
That is a percentage rate for someone who has either terrible credit history or no credit history. That is insane. Yeah, that is a very high interest rate. And yeah. Plus that price. That's a lot. That's a lot. She would have been better off getting a loan through a bank or a credit union if she could have, rather than through the dealership. Yeah, almost a quarter of your payment is going to interest for the majority of the loan.
The actual buyer herself, is that correct?
Yes.
Okay, let's move on to the last page. That'd be 4 of 4. There is an assignment box at the bottom. Do you see that?
Page 4.
Page 4 of 4.
Sorry, I
It's,
went to Exhibit 4. I apologize.
No, it's okay.
Yeah, additional terms and conditions written
Okay.
at the top.
And at the bottom, there's an assignment box. You see that?
I do, yes.
And that's blank, is that correct?
That is correct.
Is that intentionally blank?
It is intentionally blank.
So you kept the loan and you're the party that financed this?
That is correct. This loan was not sold to anybody else.
Okay, so let's move on. Let's look at what we've titled Exhibit 2. Let me know when you got that one.
I have that one.
Okay, what's the title of this?
The transaction history.
Okay, and is it fair to say that the transaction history starts at the top with the earliest transaction and ends at the bottom with the most recent one?
Correct.
Okay, so looking at the first 2 transactions, what are the dates on those?
So the first transaction was on March 14th of '24. Looks like Cynthia gave us a $100 deposit, sure to hold the car. And then on 4/27 of '24, she actually completed the down payment on the vehicle of $900 to make the $1,000.
Right, so that's those 2 payments equal the $1,000 that are reflected in the total sale price on the contract, is that correct?
Yes.
And the balance after the transaction was how much, after the April 27th?
9207.30.
Okay, and that is equal to the amount financed in Exhibit 1, is that correct?
Correct, yes.
Okay, so we'll get back to that, but let's just set that aside for a little bit. Let's look on and move on to Exhibit 3. Let me know when you've got that.
I have that.
Okay, what is that? What's the caption of it?
Notification of sale.
Okay.
Debtor's right to redeem and cure default.
And what's the date on that?
That is July 22nd of '24.
Okay, and it talks about that you're given 20 days to try to redeem or cure the default, is that correct?
That is correct.
So you had taken possession of the vehicle at the time, or shortly before the time that this letter was drafted?
Correct, yes.
Okay, and do you remember whether that was a voluntary or involuntary repossession?
I would call that voluntary.
So she contacted you and arranged for the vehicle to be turned in?
Correct, yes.
Okay, and this went out, and the address here, who provided that address?
Cynthia would have provided that address.
Because that's different from the address that she provided in the contract, is that correct?
Right, that would indicate that it had to been updated at some
Right.
point in time.
Obviously, since she arranged to surrender the car, that she would have given you accurate information on where she was residing, correct?
I would assume so, yes.
Okay, so let's put Exhibit 3 aside for a second and move on to Exhibit 4. Can you identify what that is?
This is a copy of the certified mail receipt.
Okay, and that was sent to the same address as it's listed on Exhibit 3, correct?
Correct.
And in the upper right, where there's the postmark, can you give us the date that was sent out? Or it was postmarked at least?
July 22nd of '24.
And that's the same date as the letter issued in number 3, is that correct?
Correct, yes.
Okay, let's move on to Exhibit 5. Let me know when you have that.
I have that.
Okay, can you describe for the court what that is?
This is a copy of the public notice put in the newspaper.
Okay, and with that is the affidavit of publication from the newspaper, is that correct?
That is correct, yes.
Okay, and so they're testifying that this appeared on, if you can, what day did this advertisement
Let's see.
get published?
On 7/25 of 24.
Right, and if you could just look at the notice of sale portion, when did it say that the vehicle would be auctioned?
August 9th of 24.
And where would that be auctioned?
Licking County Auto Auction?
Just down the street here, is that correct?
Correct, yes.
All right, so let's put that aside. Let's go to Exhibit 6 if you can. Can you identify that for us?
This is the sale notice from Licking County Auto Auction.
The bill of sale, correct?
Correct, yes.
And just looking at the vehicle, is that the same year, make, and model that appears on the contract?
That is correct, yes.
And again, just for brevity purposes,
Serial number?
the last 6 of the VIN, are they identical to the one that appears in the contract?
Yes, 404585.
Okay, and when did it say that the vehicle sold?
Sale date was 8/9 of 24.
Okay, and what was the net amount of the sale?
$1,660.
Okay, and you attended the auction, correct?
I did, yes.
Okay, did they make a secret deal with you, or did they open it for public auction and you just
it's-
were the highest bidder?
Yeah, it's open to public auction. It's even on the internet. Yeah,
So there was opportunity to have competitive bidders. There may have been a competitive bidder, but at the end you got the best.
yeah. At
The
that
highest.
number, there definitely was competitive
Okay,
bidders.
all right.
So he sold her the car. There was some reason why the car ended up coming back to him, and he sold it at auction, but he also purchased it at auction to then resell. Totally legit. Oh, dang it. I went to hit the play button and it accidentally went back to the beginning.
Letter indicating how much money. Right, that would indicate that it had to been updated at some
Right.
point in time.
Is that correct?
Yes.
Okay, let's move on to the last page. That'd be 4 of 4. There is an assignment box at the bottom. Do you see that?
Page 4.
Page 4 of 4.
Sorry, I
It's,
went to Exhibit 4. I apologize.
No, it's okay.
Yeah, additional terms and conditions written
Okay.
at the top.
And at the bottom, there's an assignment box. You see that?
I do, yes.
And it's blank. Is that correct?
That is correct.
Is that intentionally blank?
It is intentionally blank.
So you kept the loan, and you're the party that financed this.
That is correct. This loan was
Okay.
not sold to anybody else.
Okay, so let's move on. Let's look at what we've titled Exhibit 2. Let me know when you got that one.
I have that one.
Okay, what's the title of this?
The transaction history.
Okay, and is it fair to say that the transaction history starts at the top with the earliest transaction and ends at the bottom with the most recent one?
Correct.
Okay, so looking at the first 2 transactions, what are the dates on those?
So the first transaction was on March 14th of 24. Looks like Cynthia gave us a $100 deposit, sure to hold the car. And then on 4/27 of 24, she actually completed the down payment on the vehicle of $900 to make the $1,000.
Right, so those 2 payments equal the $1,000 that are reflected in the total sale price on the contract, is that correct?
Yes.
And the balance after the transaction was how much, after the April 27th?
9207.30.
Okay, and that is equal to the amount financed in Exhibit 1, is that correct?
Correct, yes.
Okay, so we'll get back to that, but let's just set that aside for a little bit. Let's look on and move on to Exhibit 3. Let me know when you've got that.
I have that.
Okay, what is that? What's the caption of it?
Notification of sale.
Okay.
Debtor's right to redeem and cure default.
And what's the date on that?
That is July 22nd of 24.
Okay, and it talks about that you're given 20 days to try to redeem or cure the default, is that correct?
That is correct.
So you had taken possession of the vehicle at the time, or shortly before the time that this letter was drafted?
Correct, yes.
Okay, and do you remember whether that was a voluntary or involuntary repossession?
I would call that voluntary.
So she contacted you and arranged for the vehicle to be turned in?
Correct, yes.
Okay, and this went out, and the address here, who provided that address?
Cynthia would have provided that address.
Because that's different from the address that she provided in the contract, is that correct?
Right, that would indicate that it had to been updated at some
Right.
point in time.
Obviously, since she arranged to surrender the car, that she would have given you accurate information on where she was residing, correct?
I would assume so, yes.
Okay, so let's put Exhibit 3 aside for a second and move on to Exhibit 4. Can you identify what that is?
This is a copy of the certified mail receipt.
Okay, and that was sent to the same address as it's listed on Exhibit 3, correct?
Correct.
And in the upper right, where there's the postmark, can you give us the date that was sent out? Or it was postmarked at least?
July 22nd of '24.
And that's the same date as the letter issued in number 3, is that correct?
Correct, yes.
Okay, let's move on to Exhibit 5. Let me know when you have that.
I have that.
Okay, can you describe for the court what that is?
This is a copy of the public notice put in the newspaper.
Okay, and with that is the affidavit of publication from the newspaper, is that correct?
That is correct, yes.
Okay, and so they're testifying that this appeared on, if you can, what day did this advertisement
Let's see.
get published?
On 7/25 of '24.
Right, and if you could just look at the notice of sale portion, when did it say that the vehicle would be auctioned?
August 9th of '24.
And where would that be auctioned?
Licking County Auto Auction?
Just down the street here, is that correct?
Correct, yes.
All right, so let's put that aside. Let's go to Exhibit 6 if you can. Can you identify that for us?
This is the sale notice from Licking County Auto Auction.
The bill of sale, correct?
Correct, yes.
And just looking at the vehicle, is that the same year, make, and model that appears on the contract?
That is correct, yes.
And again, just for brevity purposes,
Serial number?
the last 6 of the VIN, are they identical to the one that appears in the contract?
Yes, 404585.
Okay, and when did it say that the vehicle sold?
Sale date was 8/9 of '24.
Okay, and what was the net amount of the sale?
$1,660.
Okay, and you attended the auction, correct?
I did, yes.
Okay, did they make a secret deal with you, or did they open it for public auction and you just
it's-
were the highest bidder?
Yeah, it's open to public auction, it's even on the internet, yeah.
So there was opportunity to have competitive bidders, there may have been a competitive bidder, but at the end, you got the best.
Yeah, at that
Nice.
number, there definitely was competitive
Okay,
bidders.
all right. Let's move on to Exhibit 7, please. Can you identify that for us?
This looks like the letter indicating how much money Cynthia owes us after the sale of the vehicle.
Okay, so it's the post-auction notice, and it's dated what, when?
This is dated November 4th, 2024.
And that was the same address that was on the previous notice, is that correct?
Correct.
And that address information was provided by the borrower, is that
Correct.
Okay. So just to wrap up, let's go back to Plaintiff's Exhibit 2. That's the transaction history. So looking here, you've got, it says an entry of August 12th, it says car returned, and that was equal to the amount that you netted out at the sale, correct?
Yes, $1,660.
And you applied that 100% to the balance?
Correct, yes.
Okay, and so based on what netted out after the sale, what is the total principal balance that's remaining on this loan outstanding?
Looks like $6,183.73.
All right, and you incurred some fees, and there's a fee category there. What was the total number of fees for doing the sale ad and paying for the car to be sold at auction?
$79.
Okay, and I guess that's all the questions I have for you at this time. I think the defendant may have some questions for you.
All right, Ms. Trufant, you have a right to ask this witness questions at this time if you wish, or you can certainly call him as a witness during the presentation of your case in chief. Do you have any questions for Mr. Campbell?
Yes.
Go right ahead.
Okay, so when I bought the car, I was under the impression that it was a lease. The lady that sold it to me told me that it was a leased vehicle and I would pay her bi-weekly. and
I
could
object, this
return
is
the car.
testimony, Your Honor.
So, Ms. Trufant, as I indicated, well, I haven't indicated that yet, you'll have the opportunity to testify on your own behalf, whether you're called as a witness by the plaintiff or testifying on your own behalf in your presentation of your case in chief. But this portion of the trial is just if you have questions. So do you have questions for this witness?
No,
Alright.
I don't know how court works. I don't go to court.
That's
so.
right. Very well. Mr. Campbell, you may step down. You can return those exhibit copies to counsel. Your next witness, counsel.
That's, at this point, subject to requesting admission of the exhibits, we'll rest at this point.
Well, let's go ahead and address your exhibits then. Are you moving all 7 of them then?
We would like to at this time.
All right, so, Ms. Trufant, the plaintiff's asking me to admit those exhibits that the witness just testified to. I think you got a courtesy packet there.
Yeah.
Yeah. Do you have any objection? If I grant that motion, that means I can consider them in determining whether or not the plaintiff has met its burden of proof of preponderance of the evidence here. Do you have any objection to any of the exhibits coming in?
The only thing I got mailed to me at my parents' house was the letter that was owed, like the remaining balance owed.
Okay, well,
I
let's
never
go
got
through.
anything else mailed
Yeah,
to
let's
me.
go through one at a time. So the first one is the sales contract. Do you have an objection to that exhibit coming in?
No.
Okay, so that'll come in without objection. 2 is the transaction history, basically a reflection of financial transactions here relating to the loan. Do you have an objection to states or to plaintiffs 2 coming in?
No.
All right. 3 is that letter telling you that they were going to go ahead and sell it, and that you could bid on it if you wanted to. Do you have any objection to that letter coming in?
Never received this letter.
Okay, so you do object to that?
Yeah.
Okay,
May I make an argument on it, Your Honor?
sure.
I mean, the document speaks for itself. I mean, it's up to the court to, I would ask the court to consider it. I mean, she can give testimony as to why she didn't get it. I mean, we'll talk about Exhibit 4 when we get to Exhibit 4, but I think it's a facial document that's submitted in the order of course of business, so I ask it be admitted.
I will go ahead and overrule the objection and admit plaintiffs 3. Obviously, it'll be up to the court to determine what weight to give to the exhibit. Moving along, Ms. Trufant, we have Exhibit 4, which is apparently a photocopy of the front of a certified letter along with the certified mail receipt. Do you have an objection to that exhibit coming in?
I don't remember getting this one either, so I'm gonna object it, because unless this was the one that told me the final balance.
I believe that the testimony was that this was what what Exhibit 3 was sent in. So there's been an objection, Mr. Lubes. You want to address that?
Well, again, for the same argument, Your Honor, I mean, the document says what it says. It was generated in the ordinary course of business. It has to be admitted, and then the court can take whatever evidentiary value deems proper.
Very well. I'll overrule the objection, admit plaintiffs 4. And again, it'll be up to the court to decide how much weight to give that evidence. 5 is the notice of sale purporting to inform the public, rather, that there's going to be an auction including this particular vehicle. Do you have an objection to plaintiffs 5?
Yes, because I don't live in Newark. I live in Columbus. I don't live here.
Okay, there's an objection here, Mr. Lubes.
Again, it's a document that was generated in the order of course of business. We can have argument at closing about the compliance of that with the applicable law, but we ask it to be admitted for consideration by the court.
Very well. Court will admit that over objection. Wait to be granted to be determined. 6 is the basically the record of what happened at the auction. Ms. Trufant, do you have an objection to that coming in?
Nope.
Okay, so that'll come in without objection. And then 7 is the letter telling you, purporting to have informed you of the outstanding balance that you would owe on that loan. Do you have an objection to 7 coming in?
No,
All
because
right.
that was the letter I got.
So 7 will come in. So basically, all exhibits have been admitted on behalf of the plaintiff, and it should be noted that the defendant's objections to 3, 4, and 5 were overruled. That being said, is the plaintiff rest?
It does subject to any kind of rebuttal testimony.
Certainly. So, Ms. Trufant, the plaintiff has rested their case. It is the plaintiff's burden to prove by preponderance of the evidence that you're liable on this loan. You're not required to call any witnesses or testify on your own behalf, but you certainly have every right to. Other than yourself, do you have any witnesses that you'd like to call?
Yep, my dad.
Okay, go ahead and announce his name for me, please.
Robert Trufant.
All right, sir, please come forward and be sworn.
Just turn and face me, raise your right hand. Do you solemnly swear or do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth under penalty of perjury? Have a seat, sir. spell your last name?
It's Robert Poltrafont. Last name is spelled T as in Tom, R-U-F as in Frank, A-N-T.
Thank you. And your address?
Madison Township, Ohio, 43232.
Thank you, sir.
All right, now, obviously, you know, your voice is pretty low. We need you to try to keep it up as much as possible because we are recording these proceedings. The recording may become necessary for further proceedings in the case. Ms. Trufant, it's your witness, so you can begin asking your questions.
Can you explain what happened when I bought the car?
You have to be a little bit more specific than that. Just ask him what you want him to say. What do you want to know?
You test drove the car with me, right? The first time. What happened?
The transmission on the vehicle failed when I test drove it. When we took it back, they got it working to the point where it was drivable when she purchased the vehicle.
And then,
There were numerous mechanical issues. She took it in for an estimate, and the company that examined the vehicle found wood screws and wood underneath it being used to improvise repairs on the vehicle. This is probably going to be not admissible as opinion, as being only opinion, but the vehicle had done its run when she purchased it and was nowhere near worth what they were asking. I would only
object.
hope
This
that
is hearsay, Your Honor.
Well, it's opinion testimony, so I'm going to overrule the objection.
we do know that she's probably going to have to make recompense. I agree with that. She entered into a contract. She's liable. It's my only hope that the amount that has to be paid back is commensurate with the value of the vehicle at the time of purchase.
Any other questions for the witness, Ms. Trufant?
do you agree that I would pay the damages that I caused for the back of the car and the
I
mirror?
don't think the damages that you caused were significant. Again, my focus would be on proper recompense for the value of the vehicle at the time of purchase. This is just my opinion, maybe a few $1,000s, but certainly nothing more than that. The auction is obviously commensurate with what I would feel on it.
One last question. Do you think the way I dropped the car off was good with the text messages telling them to send me a final bill?
Well, what's important, honey, is that you advised them that you were voluntarily returning the vehicle as the collateral that was on the loan.
All right, any other questions, Ms. Trufant? Mr. Loops?
No, nothing.
All right, Mr. Trufant, you may step down. Thank you, sir. Do you have any additional witnesses other than yourself? And do you wish to testify on your own behalf?
I mean, yeah.
Okay, come on up to be sworn. If you're going to be testifying about anything, make sure you bring that with you. If you're... Okay.
Do you solemnly swear or do you affirm that the testimony you're about to give is the truth, the whole truth, and nothing but the truth, and nothing but the truth?
I do.
Have a seat. Just a moment, okay?
Just take a deep breath.
I'm sorry, I'm not used to going to court. I don't do this. I work full time and I work for everything I have. And I needed a vehicle to run.
Okay. You got to be sworn in first, okay?
I'm sorry.
So, give your name and spell your last name.
Cynthia Trufant. Trufant.
Thank you, and your address.
My mailing address is Columbus, Ohio. Madison Township. My apartment address is Columbus, Ohio. I do not get mail at that address.
Okay. So, deep breath. All right. There's no lawyer to take you through your testimony, so you just tell me what you want me to know.
I bought the car under the impression that it was a lease. I have the paperwork in my vehicle in an envelope. The car was a lease. I'm not buying the car. I was under the impression that I paid it bi-weekly, and then I could return it any time and not be told, not be held liable for any damages, for anything that I would pay damages I caused, not vehicle issues. There was multiple problems wrong with that car. They wood taped it. The engine chassis, when I went to Valvoline, they said the engine was gonna fall out of the car. Like it was wood screwed. The transmission, it jumped every time I would go and drive. When I first test drove it with my dad, it wouldn't accelerate. We made them aware of the issue. They took over 4 weeks to even get the car fixed. And in the time being, I told them I needed a vehicle to get to work. I was in the process of paying $800 a month for my Nissan, and I needed to get my Nissan back because I can't afford it. Like, I can't afford to even breathe, let alone pay them for a car that died on me. Like, and I returned the car back to them, and I'm responsible for the damages I caused. I broke the side view mirror. I took it through the car wash, and the back of the car fell off. Like, when I went through the car wash, the back of the part, I don't know what it's called, I will pay for those. But anything else, I don't think I'm responsible for, because that car had overdone its miles. It had over 250,000 miles on it. It wasn't 201,000 miles. I put a couple miles on it, but it was not drivable. Like, it would growl when I would accelerate. It wouldn't speed up like it was supposed to. The tail light didn't work. Like, my brake light didn't work. There was no working air conditioning in it when I bought it, so I had to fix that myself. The brakes on it were just not, and they were not good. Like, it just wasn't a good car. And I made a full mistake going to this dealership because I was told to go to them. I meant to go to Buckeye Motor Car, not to All Star Motor Sales, because All Star Motor Sales, I've never heard of them. I'm not from Newark. I'm from Columbus. I went to go buy a car because I wanted to get a cheaper car than what I was doing with my Nissan. So, I'm sorry I'm emotional, but I'm like, this is messed up.
All right, is there anything else you'd like to add to your testimony?
No.
All right. Mr. Lubes, Cross?
You didn't bring your exhibits with you, did you?
I don't have any exhibits.
That's all right, I'll give them. I can use the.
I think he's referring to the plaintiff's exhibits.
Yeah, they're on the thing.
So I just want you to look and tell the court on exhibit 1 there that's been admitted. And my client testified. The odometer reading, you said.
Yeah.
It says 201,359. Are you saying that wasn't the amount?
No, that was the amount when I bought it.
Okay.
But I had put a couple miles on it. Like, it was at 250, I believe, when I dropped it off.
Okay. Well, let's look at exhibit 6.
I don't think that that's accurate. I don't think she would have been able to put 50,000 miles on in a month or two, especially not if it was being repaired for 3 weeks.
That's the bill of sale from the auto auction itself.
Yeah.
I just want to be fair to you on this. There's an odometer reading that's right underneath the year, make, and model of the vehicle.
Oh, yeah, 207. Okay,
Okay,
I
so-
don't remember how much I put
No,
on
but I
the car.
mean, are you just? Do you think that's a fair assessment
Yeah,
of what when?
yeah, because I
traded the
don't
car?
remember. I only had the car for, I think, a month. I didn't keep
Well-
it that long.
Okay. So the contract date states April 27th to 24 of last year. Is that the date you took possession of the vehicle?
Yeah.
Okay.
I believe so.
And then, looking at Exhibit 3, that's dated July 22nd, and we've got testimony from Mr. Campbell that's about the date, maybe a couple days after when you turned in the car, right?
No, I turned this car in way before then. I turned this car in. I bought my GMC May. Can I call for receipts real quick? Can I
No.
go grab my
I mean,
receipts?
Did you bring, they're with you here?
They're on my phone.
Well, I mean,
Can I grab them?
you can, yeah.
Okay. Because I'll grab the receipt from when I bought my other car. Because I bought that car and returned their car the same day. Sorry.
Is this just to assist you in remembering when you purchased your other vehicle?
Yes.
I'm willing, I'm not,
Yeah.
I mean,
I
my
think an
point,
approximation is probably sufficient, Ms. Trufant.
It was like the end of May. I like bought that car. I had it for like less than a month.
Okay, so we're thinking it was July, you think it's May.
Yeah,
But
because I
either-
had it for.
It's okay, it's okay. I just want to point out, there was 200, you agree that there was 201,000 miles plus when you bought it in April.
Yes.
When it went to auction, it had, I think, what, over 207,000.
Mm-hmm.
So you had put on, unless the auction people were driving around, you'd put on
Yeah, I
over
drive
5,500. I know, but I'm saying,
Yeah.
you said you turned it in May.
Yeah.
You bought the car in April. They
Yeah.
would have been putting 5,000 miles on the vehicle in a month.
It would, because I drive a lot. I drive for my job. I
No, I
drive
get
for
it,
my
but-
job. Like, I drive
Right,
out of
but-
the city. Like,
No, so you think it's reasonable that
Yeah.
there's actually, you put over 5,500 miles on the car?
I did. I'm
Okay.
not gonna say I didn't, because I did. I put those
Okay.
miles on there.
I don't have any other questions here.
Is there anything that you'd like to add to your testimony based on the questions that Mr. Lubes asked you?
He didn't ask me any questions besides the miles.
Okay, then you can go ahead and retake your seat.
Okay.
And you,
You know, for a car that wasn't drivable, she sure put a lot of miles on it in that short period of time.
you rest your case.
Yeah.
All right. Mr. Lubes, did the plaintiff wish to present any testimony or evidence in
I
rebuttal?
guess the only question before we get, I don't think we have any rebuttal, just closing. Do you want the originals or is what you have?
I think what I have is fine. It,
Okay.
It
That's fine.
comports with everything that your witness testified to. All right. Closing arguments, Mr. Lubes.
All right, yeah, Your Honor, there's basically three statutes at play here. It's two of them are out of the Retail Installment Sales Act. That's 1317.12. That puts in the notice of cure requirements and things of that nature. 1317.16 talks about the sale and the need to put the requirements therein, and the notice of deficiency, that the last exhibit there that's after the sale is under the regular UCC chapter, that's 1309.6.6. There was testimony about her living either in, I guess, Franklin or Madison County. The statute, the relevant statute says that the sale ad is to appear in the county where the auction is going to take place. So the reason why he chose the paper he chose was because it's in general circulation in Licking County, which is where the vehicle was sold. We think we met our burden of proof about the sale of the vehicle. I would mention that, I mean, it is a used vehicle, and whatever issues, I guess she even testified that they did some repair to it at some point. She drove it, she put a lot of miles on it, and then she voluntarily turned it in. We're not saying she's a bad person. We're saying that after the vehicle went through a public auction as required under Ohio law, that there's still an outstanding balance. The only final thing I'd add is we asked her ahead of time here, and to be honest, Your Honor, this is the first time in my experience with a rocket docket. So we didn't have much opportunity to reach out to her ahead of time, but when we spoke ahead of time, said, hey, do you want to reach some kind of settlement or something like that? She said no, she wanted to go to trial. I'm willing, if it's up to the court and the defendant, obviously, if we hold off on a ruling for a certain period of time, that we can maybe go forth. I imagine the answer is the actual email that you still have,
Got it, Yahoo.
well, the one you used to file your answer.
I didn't file an answer. I called.
The email that you sent the court saying that you wanted to have a hearing.
Oh,
Yeah.
yeah, it's on Yahoo.
Yeah, I'm willing to agree to a delay on a ruling for up to 30 days or something to see if she's willing to accommodate some kind of deal. I mean, we're not looking to extract every penny out of her. We're just looking to make a fair deal and try to reclaim some of my client's money that's owed on the account. It's up to her and obviously the court. But we think we've proved all the elements of our case. We think we've proved the prayer of relief. So we'd ask for judgment in the amount of $6,183.73, plus the contract rate at 23.99% per year from the default date of August 12th, 2024, plus those fees of $79 and court costs, and neither the court costs or the fees will accrue interest.
All right, thank you, Mr. Lubes. Ms. Trufant, closing argument is the opportunity for a litigant to comment upon the evidence that the court has heard and what they think it shows. It's not evidence. You can't bring up anything that neither you or Mr. Campbell testified to. And you don't even have to make a closing argument if you don't want to. But it is your opportunity to argue why you think the plaintiff has failed to meet its burden and why they're not entitled to judgment. So anything you want to say?
I'm willing to, I don't want to settle, but like, I'm willing to pay for the damages I did. I'm living paycheck to paycheck.
Sure. Well, the court's not prepared to issue a verdict from the bench anyway. I'm going to take the matter under advisement. To translate, and he spoke pretty much English there. He wasn't speaking lawyer legalese. But I think what the plaintiff's attorney is saying is that before we even, I even return a verdict, they're willing to work with you as far as voluntary payments and things of that nature. And you're certainly welcome to use my jury room now at the conclusion of our trial if you guys would like to sit down and talk. And if you come up with an agreed judgment entry, then you can submit that and I'll sign off on it. If you don't come to an agreement, then I'll issue my ruling within the next 30 days.
Okay.
All right? Anything further on behalf of the plaintiff?
No, Your Honor.
Anything else on your behalf, Ms. Trufant? All right, very well. Court's going to stand in recess. Thank you.
All rise.
Okay, we're back on the record in the All-Star Motor Sales versus Trufant case. It's 25 CVF 391. The court heard testimony in support of the plaintiff's claim and testimony from the defendant contra that claim. The court reserved ruling and the parties were ushered into the jury room to determine whether or not they could reach a mutually agreeable resolution, and it would appear that they did. So, Mr. Lubes, you've handed me a proposed judgment entry which reads as follows. By agreement of the parties, judgment is hereby entered in favor of the plaintiff and against Cynthia Trufant in the amount of $5,400, plus interest at the rate of 8% annually from April the 21st of 2025. By further agreement of the parties, plaintiff has agreed to withhold execution on said judgment so long as defendant Cynthia Trufant makes payments of $150.00 to the plaintiff's attorney beginning on July the 15th of this year and continuing thereafter, 15th day of each month at an interest rate of 0%, that's handwritten in, until the judgment is paid in full and therefore settling the debt. If the defendant fails to make any monthly payments to plaintiff's attorney, then plaintiff shall have the right to execute on the judgment for the remaining balance due and owing on the account. It is therefore ordered, adjudged, and decreed that judgment is hereby entered in favor of the plaintiff and against defendant Cynthia Trufant in the amount of $5,400 plus interest at the rate of 8% per annum from April 21st, 2005, plus the costs. Mr. Loops, does that accurately reflect the agreement that you've reached with the defendant?
It is, and the key is if she makes all her payments, and if she makes them all before the last date, $5,400 is all we're going to want.
Okay.
And if she defaults and there's a principal balance left, it'll incur 8% from the date of the last payment.
Okay, I was kind of confused about that, how it went from 8% to 0% and then back to 8. Ms. Trufant, does this accurately represent the agreement that you've reached with the plaintiff?
Yes.
All right, very well. Well, the file's on my desk. We'll cause that to be filed with the clerk, and we'll mail copies to the parties, so you guys are free to go.
All right.
Thank you very
Make
much.
sure it's mailed to my 4996, because that's where I get my mail.
I think that's our that's the address that we have as of record for you.
Yeah.
Okay, very well. Have a good day.
Thank you, Your Honor.
Thank you.
That was a much better resolution. I hope she's able to maintain it, because you know darn well if she defaults on even one payment, they're going for all of it.
Drive safe.
And that's some arraignments.
Good afternoon. Are you Miss Cody?
Yes, sir.
Miss Cody, do you
Your
understand
Honor.
your rights in court today?
I don't know why I'm here, but yeah, I got the
Okay.
general
Did you watch
idea.
the video?
Yeah, as much of it.
Did you get a copy of the complaint, the piece of paper that tells you what you've been charged with?
Aggravated menacing?
Yeah. Did you read it?
Yeah, but I don't feel like I'm guilty of that, but
Okay. Well, it is called aggravated menacing. It's a misdemeanor of the first degree, which carries up to 180 days in the county jail, up to a $1,000 fine. That's the charge. Doesn't mean it's true. You understand that?
yes, sir.
You have the right to have me read your complaint out loud in its entirety if you'd like, but it's not required. Would you like for me to read it?
No.
Okay. Well, how would you like to plead?
I guess no contest, because I don't know what's going on. I don't know if I'm guilty or innocent of the charge, because I haven't seen lawfully what the ordinance is that I'm not compliant with.
Well, I tell you what I'm going to do. I'm going to actually enter a plea of not guilty on your behalf because you seem to be somewhat confused about what's going on, and that way we'll leave all your options open. Can you confirm your address for me, please? Does the mail come straight to the house, or do you have a P.O. box in Utica?
Going straight to the house.
Okay. Do you work?
Yeah, I was working at Owens.
For who?
Owens.
Okay. Well, let me take a quick look here at the file, then we're going to talk about your bond. So just sit tight for me, okay?
Sure.
Who do you live with there on Homer Road?
Jason Messenger.
Like a friend or a romantic partner or what?
A roommate.
Roommate. Okay, gotcha. And I still didn't catch where you said you worked. Where is it again?
Where am I now?
No, where do you work?
Oh, Owens.
Bob Evans?
Owens.
Owens. Okay,
It's
now
Morton.
now I hear you. Okay. How long have you worked for Owens?
Since December 12th, maybe.
Okay. Do you think you'd like to have the assistance of an attorney in this matter?
Well, if you already entered a plea of not guilty, why do I need an attorney?
Well, you don't need to. You don't have to have one if you don't want one. But I was going to
I
explain.
don't understand. I'm sorry, sir. I don't understand what's going on.
Well-
You said you're entering a plea of not guilty. For
I
me.
entered the plea of not guilty on your behalf because, as I mentioned, I thought you sounded a little confused about what was going on here, and I want to give you the opportunity to get caught up to speed. The benefit of having an attorney is somebody who knows how the law works and can talk to you about your case, about how you may want to resolve it, whether or not you've got defenses that you could argue, and in general, try to get you the best possible outcome. Now, if you don't want a lawyer, you don't have to have one. I'm inclined to release you on what's called your own recognizance, which basically just means I'm going to go ahead and order that you be released from the jail after signing some paperwork. But now the
Sure,
case
I
is
have
going-
no,
What's that?
sure, I have no idea what really is going on here. I feel like I have no clue. Really.
Okay. Now, do you take any medications?
I used to,
Okay,
but
but you
for a
haven't done
while.
lately?
No, sir.
Okay.
Your Honor.
Let's see.
I feel like I'm totally in the dark here.
So here's what I'm going to do. I'm going to release you on your own recognizance on one condition: you're not to be in possession of any weapons. This case is going to get randomly assigned to a judge. You'll know when to come back to court because we'll send you a letter telling you when. Plus, you can call the court if you want to find out. But we will send you the letter. If you want to get a lawyer, you can get an application for a lawyer at the jail. But since you're going to be released, it'll be your job to get it turned in. The jail will not do that for you. If you don't want to get a lawyer, you don't have to do anything. But if you do want a lawyer, then you need to get that application and get it filled out and mailed back into the clerk's office. Do you understand?
Yes, sir.
All right. So, do you have any other questions today?
No, I don't believe so, sir.
Then you
Your
may
Honor.
go with the officer, Ms. Cody. Thank you.
Thank you.
Nicholas Harrell? Good afternoon, sir. Are you Mr. Is it Harrell?
Harold.
All right. Mr. Harrell, you understand your rights today?
Yes.
Did you get a copy of the complaint?
Yes.
Did you read it?
Yes.
Do you understand you've been charged with domestic violence?
Yes.
That's a misdemeanor of the first degree. It carries up to 180 days in jail, up to a $1,000 fine. Understand?
Yes, sir.
Now, Mr. Harrell, you have a right to have me read your complaint out loud if you want, but it's not required. Would you like for it to be read?
No, that's okay.
Okay. How do you want to plead?
No contest.
Now, a no contest plea does admit guilt. However, a no contest
Yeah.
plea admits the truth of the facts that have been alleged against you. So if I read through the police reports and witness statements, and there's enough there to back up what they're claiming happened, I would find you guilty. Not only is domestic violence a misdemeanor of the first degree today, if I accept your no contest plea and enter conviction, if you were to be charged with domestic violence at any time in the future in the state of Ohio, it could be filed as a felony level offense. And the felony level offense carries potential of prison time. Understand?
Yes, sir.
So if you want to enter a plea of not guilty and get an attorney's assistance to try to deal with this, obviously you have that option. Would you like to have an attorney?
No.
No?
No.
Okay, well, then if at any time during my questions you just changed your mind, you just let me know. First and foremost, Mr. Harrell, as you stand there, I have to presume that you're not guilty, okay? It's called the presumption of
Yes.
innocence. You understand?
Yes. Yes, sir.
You also, it's the prosecution's burden of proof in order to get you found guilty, they have to prove it beyond a reasonable doubt. You understand that?
Yes, sir.
You have the right to an attorney if you want one. You can hire one of your own, but you're also eligible to ask the court to give you one for free. So we provide counsel for you at no cost if you qualify. Was it your intention to give up your right to a lawyer, or do you think you'd like to have a lawyer?
Yeah, I think I'd like to have a lawyer, actually.
All right, then let's do a not guilty plea. What is your current address? All righty. And are you employed? Do you go to school? What do you do?
I am employed. I work at Wendy's downtown.
Okay, and how long have you worked there?
About 4 months.
Okay. Let me take a quick look here at the file, and then I am going to we are going to talk about your bond. So sit tight for me, okay?
Yeah.
And how old are you?
19.
Just turned 19, correct?
Yes.
All right. Well, based on what I see here in the file, I do feel it's appropriate to release you on your own recognizance at this time on two conditions. Number one, you're not to have any violent contact with any family or household members. So I'm not prohibiting contact completely, but if things get out of control, cops get called, even if no new charges get filed, your bond could get revoked, and you're stuck down there until the case gets resolved. The other condition is that you're not consuming alcohol or drugs while the bond is in place. All right?
Okay.
This is going to get randomly assigned to a judge and set for a trial. Unless you get a lawyer, all the notices are going to go directly to you. So make sure the address on the bond that you sign down there is current and correct. Furthermore, you can get an application for a court-appointed attorney, meaning one that wouldn't cost you anything. Those are available at the jail. You can get one, but you have to turn it in after you get released. Understand?
Yes.
And don't wait until the day of your trial to do that. Do you understand that too?
Yes.
All right. Do you have any other questions today, Mr. Harrell?
No.
Then you may go with the officer. Thank you.
Thank you.
Bree Jones. Good afternoon.
Your Honor.
Are you Miss Jones?
Yep.
Miss Jones, do you understand your rights in court today?
Yes.
Did you receive a copy of the complaint?
Yes, I did.
Did you read it, and do you understand that you've been charged with one count of theft?
Yes.
That's a misdemeanor of the first degree, which carries up to 180 days in jail and a $1,000 fine. Understand?
Yes.
Now, you have the right to have me read that out loud if you want, but it's not required that it be read. Do you want me to read it?
No, that's all right. I read it.
Okay.
Thank you, though.
How do you want to plead?
I'm not guilty.
What's your current address?
Zanesville,
Are you employed?
43701.
Are you employed?
Yes.
What do you do, Miss Jones?
I work at Steak and Shake in Newark.
Okay, and how long have you worked there?
I just started there, so I'm at risk of losing my job being in here.
All right. Were you scheduled to work today?
Yes.
What time?
4 p.m., so I can still make it.
Well, yeah. I mean, I am going to go ahead and cut you loose on a recognizance bond, but I think it's
I
going to take them a
appreciate
little
that.
while to get you processed out. So don't take it out on them. They're just doing their job.
I won't. Hey, I can get an Uber there. I live with my manager, so it's pretty, she understands, but she still can't pull too many strings, you know what I mean?
Right. Okay. So
At least I got arrested in my work outfit, so I got my work outfit, so.
that's not good advertising for the company.
No, not in it, but I mean, I have it in my stuff. Oh, wait, never mind, I don't. She has her
Oh,
car.
well, yeah, that's convenient. Well, as I said, you're going to be released on your own recognizance. The case will be randomly assigned, set for trial. You'll get notice through the mail until you get a lawyer, unless you
Okay.
get a lawyer. You can hire one if you want. You can go court appointed. The application is even available at the jail, but since you're getting out, they won't send it in for you. That's your job. And the key
Okay.
is to make sure you do not wait until the day of your trial to deal with getting an attorney if you want one. Understand?
Yes, I understand.
All right. Do you have any other questions today?
Nope, pretty understanding. Thank you.
Thank you. You may go with the officer. Good luck. Trey Long. Good afternoon, sir. Are you Mr. Long?
Yes, sir.
And Mr. Long, do you understand your rights in court today based on watching the video?
Yes, I do, Your Honor.
Did you receive a copy of the complaint?
Yes, I did.
Did you read it and do you understand you've been charged with a single count of assault?
Yes, Your Honor.
Okay, now that's a first-degree misdemeanor, carries up to 180 days in jail, up to a $1,000 fine. It's not required, but you have a right to have your complaint read. Did you want me to read it?
No, I pretty much double-checked it a couple of times. I'm pretty sure I understand all of it. Thank you, though, Your Honor.
Alrighty, and how do you want to plead to that charge?
Not guilty. If you guys could, I was wanting to ask if you could give me appointed attorney for me. Sorry, I have a speech impediment a little bit.
That's all right. Yeah, the applications for court-appointed counsel, they have copies down there at the jail, so you can get one down there. Let me take a quick look here at the file after I ask you this. Are you employed?
Yes.
Where do you work?
Wendy's, Hebron Road, Buckeye Lake, Ohio.
What is it?
Wendy's, Hebron Road, Buckeye Lake, Ohio.
Gotcha. Okay. All right, let me look at this file here real quick, and then we're going to talk about your bond. So sit tight, okay? How long did you say you've been working at that Wendy's?
I'd have to say a month and a half at the most, Your Honor.
Okay. All right, Mr. Long, here's what I'm going to do. I will release you on your own recognizance on 2 conditions. Number 1, you're not permitted to have any contact either directly, indirectly, through third parties, or on postings to social media with the alleged victim of this case, the person whose initials are KW. Number 2, you're to take all your medication as prescribed and be in compliance with your doctor's dosages and frequency. This case will be randomly assigned to a judge and set for a trial. You're going to receive notice through the mail. What is your address, sir? And who do you live there with?
My mom. I do want to be honest, Your Honor, if I may speak for a second. I am homeless. I'm sorry.
Go ahead.
I'm homeless at the moment, so it just made it even worse and more easier for them to come pick me up. I don't really have anyone to be released to. It's been hard trying to get a hold of my mom in here.
Well, I mean, you can walk from the jail to 10th Street, right?
Yeah, of course. I mean, I don't know. I don't know. Yeah,
Okay.
Yes, Your Honor.
I think the rain's passed, so you should stay dry, but it's going to take them a couple hours to process you out, so you can keep trying to get in touch with your mom. This case is going to be randomly assigned and set for a trial. We'll send you notice through the mail, so make sure your address is correct on your bond paperwork. Grab an application for court-appointed counsel down there. The COs can give it to you, but since you're going to be released, it'll be your responsibility to get it turned in. You understand?
Yes.
Okay, so the main thing is don't wait until the day you're supposed to be in court again to fill that out and turn it in. Do it well before the next time you're supposed to be here, all right?
Yes, sir.
All right,
Thank
you
you
have
very
any other
much.
questions today, Mr. Long?
No, Your Honor.
Then you may go with the officer. Thank you.
Thank you very much.
All right, next we have Charles Maynard. Good afternoon, sir. Are you Mr. Maynard?
Yes, sir.
All right, Mr. Maynard, you're here for 2 reasons. One is because I issued a warrant for your arrest back in November when you didn't show up for a pretrial in this paraphernalia charge, and then you caught a new charge over the weekend. So let's back things up for a minute. Do you understand your rights in court?
Yes, sir.
Did you receive a copy of the new complaint?
Yes, sir, I did.
Did you read it? Do you understand you've been charged with failure to disclose personal information?
Yes, sir.
That's a 4th-degree misdemeanor, carries up to 30 days jail, up to a $250 fine. I could read that for you if you want in its entirety, but it's not required. Do you wish for it to be read?
Please.
Alrighty. The Newark Police Department is alleging that on or about April the 19th of this year, within that city and here in Lincoln County, Ohio, that you were in a public place, that you refused to disclose your name, address, or date of birth when requested by a law enforcement officer who reasonably suspected that you had committed, or were about to commit a criminal offense. So basically, they're saying that they're alleging that the officer had reasonable suspicion that you were doing wrong. They had the right to ask you that information. They claim you refused to. So up to 30 days and a $250 fine. How do you want to plead?
Not guilty.
What is your current address, Mr. Maynard?
Yes, sir.
Who do you live there with?
My mother.
Do you work?
Yes, sir.
Where do you work?
Shackelford Roofing.
And how long have you been with them?
A little over a year.
Alrighty. That brings us to the case that I issued the warrant on. You had a pretrial on that. It looked like, let's see. Yeah, and the lawyer that had been appointed to represent you withdrew upon your failure to appear. So you don't have a lawyer on this right now. You've got a couple of options on this one because it was assigned to me. You can stand on your plea of not guilty, in which case I'm going to set a bond today and we'll get this rescheduled for trial. Or if you want to wrap it up, you can change your plea from not guilty to guilty or no contest. It's entirely up to you. What do you want to do?
Let's just go ahead and wrap it up. I'll plead guilty. I'll plead out.
Now, before I can accept your guilty plea, I need to verify that you're doing this of your own free will. You understand that you're presumed to be not guilty, and it's always the prosecution's burden to prove guilt beyond a reasonable doubt, right?
Yes, sir.
You have the right to be represented by an attorney. If you couldn't afford one, we'd give you one for free. Was it your intention to waive that right and just end it today?
Yes, but Your Honor, I don't understand how they can charge me with paraphernalia when the driver of the vehicle stated that was his paraphernalia. It wasn't mine.
Then don't plead guilty.
Well, I mean,
Right
if you
there.
if you don't want to plead guilty, if you don't think you did anything wrong, then you should stick it with your not guilty plea.
I mean, it doesn't matter. They're going to try to bag me anyway, so we'll just go ahead and say I'm guilty. We'll just go ahead and I'll just waive it all. I'm guilty of everything,
Okay.
even the first charge.
For the
You know what I'm saying? The one that happened yesterday.
Okay.
Can we get that taken care of too, Your Honor?
We can take care of them both right now if you like.
That's awesome. Can we do that, sir, please?
Yeah. So these questions I'm asking are not designed to get you to change your mind about what you're doing. I just have to verify you're doing it of your own free will. Okay?
Yes.
So
Yes, sir.
these questions will now apply to both cases. You do understand that in both cases you're presumed to be not guilty, correct?
Yes, sir, Your Honor.
And you understand that it's always the prosecution's burden to prove guilt beyond a reasonable doubt, right?
Yes, sir.
And you know that you have the right to be represented by an attorney of your choice, or you can ask the court to appoint one, right?
Yes, sir.
And was it your intention to waive that right?
Yes, sir.
All right. Officer Riley will need to do a waiver for both cases. Now, Mr. Maynard, whether you have a lawyer or not, you still have a right to a trial, and that could be with a judge or a jury. You understand?
Yeah, I understand. I don't want no trial. Just get it over with.
That's fine. I need to make sure you know. Do you know that at the trial you would have had the right to question your accusers and to subpoena your own witnesses to compel their attendance?
Yes, sir.
You would have had a right not to testify, and it wouldn't have been held against you if you didn't. Do you understand that?
Yes, sir.
Now, if you plead guilty, you're admitting that you failed to disclose and that you had that paraphernalia. There's a thing called constructive possession, which is if you and I are both sitting on a park bench and there's like, I don't know, a stolen painting there, we can both get charged with possession of it. All right? If you plead guilty, you're going to give up those rights. The state won't have to prove anything anymore because you're admitting that you committed the offenses, and you'll give up the right to a trial. Understand?
Yes, sir.
Now, I'll sentence you today if I accept your pleas, and as I promised, we're going to wrap these up today. Have you been threatened in any way or promised anything to get you to do what you're doing?
No, Your Honor.
Are you under the influence of anything right now?
No, sir.
And are you a citizen of the United States of America?
I am, sir.
All right, very well. Then I'll accept your pleas and enter convictions upon the record. Anything you want to say about either one of these situations?
No, Your Honor.
Okay. Well, I know what pretty much went down the other day. You didn't want to get picked up on your warrants, right?
Yeah, exactly what happened. I was riding down the street going to a friend's house, and the cop turned around and you're saying tried to. I mean, he came up on me. He was saying I wasn't committing no crime. I don't understand how that's committing a crime when he just turned around. You know what I'm saying? But I mean, it don't matter. I waive everything. I don't have no statement I want to make about it. I'll plead guilty in both cases. Just try to be lenient as possible. I do have a daughter I'm taking care of. You know what I'm saying? And mother that's you know what I'm saying, getting kind of old and she's kind of ill right now. So please try to be lenient on whatever time you want to give me, Your Honor.
Okay. Okay, well, other than the amount of the fine, the sentences are going to be identical. On the failure to disclose, it's a $150 fine. On the paraphernalia, it's a $50 fine. Costs will be assessed, 2 days in jail and credit for time served.
Thank you, Your Honor.
You have any questions?
No, sir.
Then you may go with the officer, Mr. Maynard. Rocky Smith. Good afternoon, sir. Are you Mr. Smith?
Yes, sir.
All right, Mr. Smith, you understand your rights in court today?
Yes.
Did you get a copy of the complaint?
Yes, sir.
Did you read it and understand you've been charged with violation of the protection order?
Yes.
Okay. Now, that's a first-degree misdemeanor which carries up to 180 days in the county jail and up to a $1,000 fine. Any questions about that?
No, sir.
All right. Now, you have the right to have me read that out loud if you want to, but it's not required. Would you like for me to read it?
No, I've already read it.
Okay. How do you want to plead?
Not guilty.
Did you say not guilty? Because that's different from not guilty. Not guilty is guilty.
No, not guilty.
Okay. All right. Just want to make sure you get it right.
Correct.
All right. What's your current address?
Thornville, Ohio, 43076.
Okay. What do you do for a living, Mr. Smith?
I'm a union iron worker.
Okay. Did you say iron worker?
Yes.
Okay. How long you been in the union?
15 and a half years.
Longer than I've been here. Okay, so, Mr. Smith, you will be released on your own recognizance on the condition that you abide by the terms of any active CPO that's out there. This case will get randomly assigned to a judge and set for a trial, and we'll send you notice through the mail of when that's going to be. If you would like to hire an attorney, you certainly have the right to do that. If you'd like to ask the court to provide counsel for you at no cost, you're eligible to do so as well. The application form is available at the jail, but since you're going to be released, if you do decide that's the route you want to go, you'll have to turn it in. They won't do that for you. But the key is, regardless of if you want to get a lawyer, deal with it well before the next time you're supposed to be down here in court. You understand?
Yes, sir.
All right. You have any other questions today?
No, sir.
Then you may go with the officer. Thank you, Mr. Smith.
Thank you.
And Jason Smith.
And Your Honor, Jason Smith is refusing, but it sounds like he has field arrest charges that are going to be coming down tomorrow, so he would have to come back down for his arraignment tomorrow anyway.
Okay.
If we can.
And it's a bonus that it'll be Judge George tomorrow instead of me, so we can.
I kind of had a feeling that you wouldn't be too reluctant to do that. So.
I'll use the rest of the afternoon to get over it.
All right, sounds good.
You have a good one. We'll see you next week.
Yep, thanks. Have a good one.
Lusecki, I know that you know this process, but we do have to go through it each time under the People versus Anderson Michigan Supreme Court case. You understand that you've asked to represent yourself.
Yes.
You still want to represent yourself.
Yes.
You still understand the maximum penalties you're facing if convicted.
Yes.
And you understand that if you made a request to have a court-appointed attorney assist you, I would appoint an attorney to assist you. You understand?
I understand.
And you still want to represent yourself?
Correct.
Do you have any questions about any of that?
I don't think so.
If you think of any questions during the proceeding today, make sure and get my attention so I can answer them. You can ask for one and I'll provide one for your assistance.
I would like to say something about, I got a 7-day notice about a decision. And it was your record for law.
I don't know what 7-day decision you're referencing, so what one are you referencing?
Well, I had a hearing on March 5th and I got a notice and it said that you made a decision on January 29th.
So what happens, and perhaps this will answer the question, perhaps it won't, but whenever we have hearings, I require a party to file an order. And when the parties don't consent to an order, so if you both consented to it, I could sign it, then it's submitted under what's called a 7-day rule. And I sign 7-day orders all of the time because what happens is if the prosecutor, for example, submitted an order, you have 7 days to object to that order. If you objected to it in a timely manner, then we'd have a hearing regarding it. But if you don't, the court's presumption is the order was accurate because otherwise there would have been an objection. So was there a 7-day order? I can just check the court file and see if I can identify the one you're talking about. Are you talking about an order following the hearing?
It was March 10th and it said it was for the decision on the 29th of January.
All right, and so I'm seeing that order. It looks like I signed it on March 20th. Again, I signed a 7-day order when nobody's objected to it after 7 days after the prosecutor or whatever other party files it. So I signed it. It says that the matter has come before the court having reviewed the files and records herein, having heard the arguments of counsel and being fully advised of the premises hereby orders that the defendant's motion to dismiss dated January 29th, 2025 is denied for the reasons stated on.
Well, that's not true though.
Well, what's not true about it?
It wasn't denied on the 29th of January.
Well,
It
whatever
was
date
denied on the March 5th.
whatever day it was denied, it was denied. The order says that your motion that was dated.
So it doesn't have to be accurate then?
It's accurate. Your motion was dated January 29th. I denied it in the March hearing.
Oh,
Your
okay. I
motion
see
was
what you're
dated-
saying. Yes, I
Your motion
understand.
was dated January 29th.
I completely understand.
Okay, so it is accurate, yes.
Okay.
Yes.
Uh,
Well,
If you say so.
you filed the motion, you're the one challenging it, Mr. Wessel.
But I didn't file the motion on the 29th.
Well, here's the way I view it. You're the one complaining that there's an error and have established to me that there's an error. So I'm not going to take any further action on that issue, but I do want to move on to the next issue, which is the motion to adjourn trial. Did you get a chance to see the prosecutor's motion?
Okay.
Did you get a chance to see the prosecutor's motion?
The motion for June 12th.
The motion to adjourn the trial, the one that we're here for today.
I'm not sure of that. No, I don't think I did.
Mr. Ziegler, do you have a copy of your motion to adjourn trial that you can hand to Mr. Lusecki? Sure. I'm looking at the court file and the proof of service. This motion to adjourn trial was filed with the Kalkaska County Clerk on March 28th. The proof of service, hand signed by apparently Mr. Ziegler, indicates that there was a copy provided to you at US mail. So take a moment to review that motion and tell me if you've had a chance to see it yet. It's the same motion that the prosecutor brought up orally at the conclusion of our last hearing, and I told you you had the right to object to it and file a written response if you wanted, or I'd address it whenever the matter came up again before.
I've never seen this motion.
What's your mailing address?
7038 Northwest Gillett Road.
And is that the address that you have, Mr. Ziegler?
That's the address we mailed to, Your Honor, yes.
Okay,
May have other filings there before in the past.
Right. So, Mr. Lasecki, did you have a response to the prosecutor's motion to adjourn the trial?
My response to that is, this has been going on for like a year, and I would like to get it done.
So would I. So would I. But one of the ways that we need to have it done is we need to have all of the necessary witnesses present. And so I'm going to go through it this way, and I'll let you have the last word. Mr. Ziegler, if you had argument, I'd allow it. I think I fairly easily understand your motion and why you're filing it. But did you have additional oral argument wanted to offer in support of your motion?
Your Honor, just to the terms of the delay, I know this case has been proceeding for some time, but most of that delay was not at the people's request. In fact, we had a trial set, I want to say it was maybe in January, and it was adjourned at the defense request so he could file some motions. He's filed those motions. They've been denied. The requested adjournment is only for 30 days time. Your clerk provided me a date of June 12th, which Mr. Lasecki seemed to be aware of. So for that reason, Your Honor, I don't think it's a meaningful burden one way or the other to adjourn trial for 30 days to ensure that the officer can attend his training is available for trial.
Did you have further argument you want me to consider, Mr. Lasecki?
That is not accurate. It's been for trial in November. It's been changed to February. It's been changed, multiple times.
Mr. Lasecki, the court needs to make a finding of good cause to adjourn any trial. And in this case, the purported or claimed good cause by the people is that trial was set. He was made aware of the date. He brought up to you the fact that he had an officer that was set for a training on that date. And that training is for basic firearms instruction, where the Kalkaska County Sheriff's Department has arranged for payment for that, and it costs the county $300 for this officer to attend the training. If I continue the trial on May 12th, that would prevent Mr. McCormick, Officer McCormick, from receiving the training, which would generally have a negative impact on the Kalkaska County Sheriff's Department, as well as in Kalkaska County in total. And the request is simply to adjourn for a month so that he can both attend the training and that we can have the trial. That does not appear to be an unreasonable request. It's also not unreasonable for you to want to have trial, but it is accurate background that we've had this trial set multiple times at least. And at least on one of those occasions, you requested an adjournment because you wanted another opportunity to file a motion, which I let you do. It wasn't unreasonable for you to ask for an adjournment for that purpose. It's not unreasonable for the prosecutor to make a request to adjourn trial here. And more specifically, you haven't told me that there's any prejudice to you. I understand what you would probably say if I let you speak again, is that the prejudice comes just simply in the delay. You want to have this matter off of your chest and out of your mind, and I get that. I also want to get this matter resolved. But the way that I can do that best in using my time is to make sure that everyone that's necessary for trial is there. Here's the downside, is if I found some compelling argument by you, that compelling, and I decided to keep trial on, the prosecutor could, if he decided to, simply dismiss the charges and refile later. That would be a way that has nothing to do with this court's exercise of discretion, which would serve to delay your case further. So what I'm bringing up to you is that probably what you're not seeing is that even if I denied the prosecutor's request, there are potential other ways that the prosecutor could still adjourn the trial without asking me for permission to do so. I don't think that makes much sense, and I'm not suggesting I think Mr. Ziegler would necessarily do that, but it's something that would definitely affect you. It would create more prejudice because it would create more delay. So I don't find that there's any prejudice to the delay. The delay is relatively short.
I have never adjourned.
Well, I'm not really going to have a back and forth argument with you, Mr. Lasecki.
I'm not arguing.
Well, that's exactly what you're doing. When you disagree in a defiant manner in the courtroom with something that I've said, that's the definition of an argument.
True.
So we're going to disagree and we'll be fine with that, both of us. The order is that I'm going to grant the prosecutor's motion to adjourn trial.
Your light's still red, just so you know.
The red is good. The red means we're recording.
Okay, I heard green.
The red is good.
Okay, thank you.
So we're going to have the new trial date set. And I think in your proposed order, Mr. Ziegler, you had already had that new date, did you not?
I did, Your Honor.
And so I want to make sure
it's in the order.
It is in the order part. And so I'm just going to simply sign this order. Do you want me to use the separate copy, not the one that's already in the court file? There's a proposed order in the court file.
Yes, there's a separate copy.
I think I have a separate copy of the order.
Can you tell me the date that I adjourned?
No, I'm not going to go through any more of the dates. They are what they are, and
Thanks for your help.
you have the ability, Mr. Lasecki. This is not a complicated process. You've been in court during all of the proceedings, and every decision I've made, you've been looking right at me when I made them. So to the extent that the dates were not January 29th or not March 5th, the dates are irrelevant.
Well, they were
The purpose of the dates is that we were all together talking about the case. We're not going to consider covering what I view to be old ground. And this is a situation where Mr. Lasecki, again, as I told you most times, because I have to make the finding, I've generally found you to be communicative and cooperative and not difficult. That's the reason why you're still representing yourself in part. Part of it is because you've asked for that. But that right to represent yourself is also limited to the extent the court finds that you're being problematic or making it difficult for me to do what I view as fairly simple things. I'm not in a position to or want to make a change on how you're representing yourself. But if, for example, during your trial, you are so difficult that I have to rehash old things and I have to have conversations over and over again, it may make me decide in my discretion that you're not able to do the role of representing yourself sufficiently, and that you're going to cause difficulties for the court. And I'm just reminding you that if you make me make that decision, that allows the court to then force counsel upon you. I'm not telling you I want to do that. I'm telling you I don't. I want you to be able to represent yourself. But if I have to get in back and forth verbal spars with you, especially if it's in the presence of a jury, it is not going to be to your benefit. I don't allow that to happen from attorneys. I'm not going to allow it to happen from litigants, including you, even if you're representing yourself. So I'm putting you on notice. If you make me do that, particularly in the presence of a jury at a jury trial, it's going to have negative consequences to you in that you're not going to continue to be able to represent yourself. Do you have any questions about what I've said or anything I can further explain for your benefit? Is that a no? Mr. Lasecki, this is the type of behavior that's going to land you in proverbial hot water.
What do you mean? What am I doing?
You know exactly what you're doing, but I'll explain it to you very clearly and cleanly on the record so that you know further. When I ask a question of a prosecutor or a defense attorney or a witness, the required response in a courtroom is a verbal response. And it's verbal for the benefit of you, the benefit of the prosecutor, and my benefit. It records everything. That's why these lights are on. We record every part of a court proceeding so that everyone, including the Court of Appeals or the Michigan Supreme Court, has access to it later. Therefore, if I ask you a question and you don't verbally respond, it's going to, as you can see how it's affecting me right now, it's going to make me upset because it's a clear and easy process. Verbal responses are able to be transcribed.
Sir, I don't want you to get upset.
I don't want me to get upset either. And it's not a particularly difficult conversation we're having, except the way that we have to have it. Do you have any other questions that I can answer for you so that you can understand why I get upset over simple procedural issues?
No, sir.
Mr. Ziegler, do you have anything further you think the court should cover today in advance of our impending trial date?
No, Your Honor.
Mr. Lasecki, I'm going to see you at the morning of trial. That trial date has now changed, of course, but the requirement is, again, that you're here present, ready to go no later than 8:30. Do you have any questions? Most times I've broken after these hearings by offering you the ability to question the court about general procedural matters at trial. Do you have any general questions about procedural matters at trial, what happens when it happens, or so forth?
I do not.
All right, we will see you at your trial date then. Do you need to get a copy of that trial date now, or can we mail it to you?
I should probably get it now because I didn't get a copy of this, but I did get a copy of the notice of judgment.
Can you get a copy of that order for Mr. Lasecki right now? Sure. So Mr. Lasecki, just stick around for a little bit.
Okay.
We'll have the clerk provide a copy, but I just signed it today. It has a new trial date on it. Again, 8:30 more in the morning is a requirement for you and the prosecutor to be here.
And I should be here a half hour early.
Right, half hour before the start of trial, which is 9 o'clock, so no later than 8:30 in the morning.
Okay.
Yes, sir. All right, thank you. The court is in recess on this case.
God bless you, sir.
As well.
Just go ahead and wait back there.
You have the Wexford County Jail. Mr. Horowitz, is Mr. McElroy in the Wexford County Jail, do you think? Or is he here? Mr. McElroy.
He is not here.
I believe he's out.
Oh, you think he's out? Okay.
McElroy.
I see Ryan back. That is a 145 matter. Do you have another individual in the courtroom you're already on?
No, Mr. Woods in custody. That's a little later. And McElroy was recently it's a relevant term given to me from Mr. Travis, and I haven't had contact with him. His contact information doesn't work.
Well, let's start with Mr. Wood. We'll have the court officers bring Mr. Wood up, and then we can circle back to Mr. McElroy.
And just for the officers, I am asking and have asked the court for competency evaluation.
I've got a copy of it. We'll cover it on the record, certainly.
Just thinking they might want to have more than just one officer.
So court officer, yeah, I think he missed your suggestion, and I appreciate it.
He's coming back.
So, sir, my question is, do we have the ability to have multiple law enforcement officers present? And so can we do that for Mr. Wood? I appreciate the defense making that request. It makes sense in light of your filing, but we'll cover it all formally.
Thank you,
Maybe
Judge.
put down the Wood case.
No. And it just clicks on it, continues to record under that case.
Yep, as long as there should be that dial spinning on the top.
Yep.
Yep,
Yep,
that says
breaking.
it's still recording.
Yep.
So we're on the record in the matter of People versus Terrence Patrick Wood. This is file 25-5019C.
Ryan Ziegler on behalf of people, Your Honor.
Michael Horowitz on behalf of Mr. Wood.
Thank you. So we're bringing Mr. Wood in right now, but while we're now officially on this particular case, I know counsel, you've made the request. You've made a written request for a competence exam, and I know that that's generally to just providing you a little bit of advance notice about your request. To be clear, I don't view it as a necessary that you have a written request for a competency evaluation, but I appreciate having the information before. You also had made the request to perhaps have a separate court officer here as well, because apparently there were some communicative difficulties between you and Mr. Wood the last time you met with him. Is that generally consistent with what you required?
Yes.
Let's get, and I just want to make sure that's true. And if, once you have Mr. Wood present, then certainly you can make whatever further record in his presence that you need to. But Mr. Ziegler, did you also get a copy of the written request for competency exam?
I did, Your Honor.
All right, so once Mr. Wood's present, I'll ask if you had anything to weigh in on that. And then we'll proceed forward.
What? I think it was a front of the court one.
Oh,
And something else, so it shows them in custody.
interesting. Thank you.
All right, welcome, sir. Are you Terrence Patrick Wood?
I am.
Mr. Wood, we're here for a status conference today, but we're also here for a motion that was filed by your attorney. Have you had a chance to meet with your attorney prior to today's date?
Have not.
And can you describe to me, Mr. Wood, the attempts that your attorney has made in the past to try and meet with you at the jail or otherwise?
One other time, as far as I know.
So there's some background that I'm going to hear from the attorney, certainly, but I received a motion that was filed by your attorney. What I explained to him is that I didn't necessarily need a written motion. He's asking me for what's called a competency evaluation. Were you aware he was going to be asking for that?
No, sir.
So I'm going to go through it with the benefit of the attorney so that you hear everything that's going on, because there are times when lack of communication or communication difficulties between the defendant and the defense attorney make it difficult for you to get the full picture that your attorney is explaining. Ultimately, I'm going to allow you to be heard as well. I'm going to allow your attorney to speak for you, but I'm also going to allow you to be heard if you want to. But I want to make sure you bear this in mind. You have a right to remain silent. You don't have to speak in any way. If you speak at all about the underlying charges, anything that you say on the court record could be used against you. So what I'm not going to ask you about is anything related to the underlying charges. I'm only going to talk about this motion and your communication that's been going on or not been going on between you and your attorney. Do you understand what I said in that regard?
Yes.
So, Mr. Ziegler, did you get a chance? Well, let's start with your motion for a competency evaluation. Can you describe for the court on the oral record today, generally what you're asking for and why?
Your Honor, after my last meeting with Mr. Wood, well, I've had some concerns about Mr. Wood's mental status for a while now. I first met with him before the preliminary examination at the Kalkaska County Jail for a fairly lengthy meeting, had no difficulties interacting with him, discussing his case with him. The next time I met with him was at the Wexford County Jail, and Mr. Wood was substantially different in terms of his ability to discuss his case and interact with me. My concern rose to the level of contacting the jail after that and speaking with somebody about what was going on with Mr. Wood, whether they were aware of his parents' decline, whether or not anybody was attending to that. And there was a acknowledgement, I believe, and then I received a subsequent communication from the Wexford County Jail about setting him up with CMH. My next meeting with him was declined, and my next meeting after that, which was the same date, I believe, as his competency exam, Mr. Wood explained to me that he had declined the previous meeting because of he had just had surgery and had an open head wound, and then as to the newest meeting, things really went poorly. They're described at length in the motion, and I would just affirm those descriptions today. Further, I have sent copies. I did send copies of this to Mr. Wood. At my last meeting with him, he did suggest he hadn't received things I had previously sent. So I don't know if there's a reason why things sent to the jail are not making it to him, or if they're in fact making it to him and he's not understanding that. I don't have problems with the Wexford County Jail getting my communications to other persons, but Mr. Wood may be held in a different manner. He did suggest on the record at the last hearing that was adjourned that he was unable to use the phone to contact me. I don't know if that's because of the manner in which he's being held there, if he's being segregated because of his issues or what, or it's just incorrect. I don't know. But I do believe that there's a significant barrier to him assisting with his case right now due to whatever he's undergoing mental health wise, and think that he needs to be seen by somebody to evaluate it for competency. If that does not come back with concerns, I think that I guess I would have to probably address seeking additional or substitute counsel for breakdown in the attorney-client relationship. At this point, it's fairly well impossible to communicate. But I think that that's not because of Mr. Wood. I think that's because of Mr. Wood's mental health issues and stuff.
Thank you, Council. Mr. Ziegler, on behalf of the people, did you wish to respond at all to the written or oral statements?
Your Honor, I'm obviously not in a position to confirm or deny any of that. The people don't oppose the request and they don't take any position on the factual allegations.
Mr. Wood, did you wish to respond again, bearing in mind that the question is not about the underlying case at all, it's just about the communications issue and whether or not I should grant the relief requested?
There's nothing wrong with mental health. There's nothing wrong with it.
Have you recently had open head surgery?
I did have open head. I had an open head wound, yes, from an infection I had in my head.
And was that one of the reasons you refused to meet with your attorney?
I did. It is one of the reasons, correct.
Of course he's going to believe there's nothing wrong with him and that he doesn't need a competency evaluation. They never believe that they need a competency evaluation.
So when I started this hearing, I asked if you'd been able to generally meet with Mr. Horowitz, and you said you've only met with him once, right?
Correct.
At least one of the times he went to meet with you, you refused to meet with him because
that was the reason.
Because of the head injury.
Correct. You only been 2 days.
And another one of the occasions, at least Mr. Horowitz explained in his written motion, and what he's alluded to today, is that again, you refused to meet with him. You swore at him and told him in some negative terms to leave. Is that accurate?
Correct.
So when you complain, you can probably understand why my concern would be piqued. You complain about not being able to meet with Mr. Horowitz.
I didn't complain about that.
When I asked you if you'd had enough time to meet with Mr. Horowitz, You said that he'd only been trying to meet with you one time.
As far as I was aware, I'm in segregation, I don't know,
Why are you in segregation?
because of the open head wound.
So, Mr. Wood, do you understand the charges that have been filed against you?
I understand, correct?
What can you tell me about the charges? Do you know their names or the maximum penalties?
Yes, I do.
What are they?
What are the names? Who's the names?
Right, what have you been charged with?
Delivering, manufacturing methamphetamine.
And what's the maximum penalty for that offense?
I don't remember what the maximum penalty is, but life or something like that, I don't know, whatever.
So it looks like you've been charged in count 1 with controlled substance maintaining a drug house. Is that your understanding?
That's my understanding.
Oh, only a life offense. It's nothing, Your Honor. It's just a life offense.
You've also been charged in counts 2 and 3 and 4 with the offense of delivery of the controlled substance methamphetamine. Do you understand those?
My understanding.
And do you understand the maximum penalty if you're convicted? You've also been charged as a habitual offender, 4th offense notice. Do you understand that?
I understand.
Do you understand what the 4th offense habitual notice means?
Yes, I do.
What does it mean to you?
It means I can receive like up to 10 times the offense or whatever. That's
Not exactly accurate. So I want to go through it with you. The 4th habitual means if the offense that you're convicted of is punishable by less than 5 years in the state prison system, then the maximum would be 15 years by statute. So for the maintaining a drug house, 4th habitual, the maximum penalty would be 15 years. But for any offense that's punishable by 5 or more years in the state prison system, the maximum becomes life. Are you aware of that?
Yes.
So the 10 times isn't accurate, but the effect is similar. Its maximum is life in the state prison system. Do you understand that?
Yes.
So part of the case can be, if a prosecutor authorizes charges, the prosecutor then has the sole discretion to decide whether or not to offer plea offers. Do you understand that? And a plea offer would be generally, you would plead to an offense and he would dismiss others. Do you understand?
Correct.
Prosecutor might also offer plea offers where he would offer pleas to lesser offenses for dismissal of all the charged offenses. Do you understand that?
Yes.
Have you been able to talk about all of those things with Mr. Horowitz?
A little bit.
Is part of the reason you haven't been able to communicate with him because you swore at him and told him to leave?
Probably.
Is part of the reason because you had a head wound?
Probably.
Is part of the reason because of where you're being held in the Wexford County Jail? Mr. Horowitz has explained to me that he's trying to make you aware of your options. This is what this could mean. This is what this could mean. This is what this could mean. Trial, plea, as charged. But he's suggesting to me that he's concerned you don't understand when he's explaining it to you. Do you agree with that?
No, I don't.
So if he's able to sit down and explain to you, do you think you'll be able to understand?
Yes.
If he's able to meet with you, are you going to swear at him and tell him to leave?
Probably not.
He can't really give you legal advice that you desperately need if you swear at him and tell
Well,
him
my
to leave.
problem with Mr. Horowitz is I think we're just working with the county. He's not interested in anything about me.
Well,
And that all he wants to talk about is how much time I'm gonna get. That's all he wants to tell me. That's all he wants to tell me is how much time I'm gonna get for this, and that, and the other thing.
do you think it's important for you to know what time you might get?
I understand that. There is important for that, but there's other things that are important too.
Do you think an attorney's job should have to do with things like making you aware of what the potential sentence could be if you're convicted at trial?
Yes.
Do you think he should also tell you what the potential sentence could be if you accepted a plea offer?
Yes.
Do you think he should also be prepared and ready for trial if you tell him you want to trial?
Yes.
Do you think that you can work through all of those options with him if I give you additional time to discuss?
I suppose.
Your Honor, he's lonely in there. He wants someone to discuss current events and, sciencey topics like bioluminescence and, he basically, he needs the Hey Google app, but in attorney form.
Are you willing to do that?
I'm willing to do it.
Mr. Horowitz, I view your motion as filed in certainly good faith. You've explained to me what your concerns are. I had extended what I'm viewing as an extended colloquy with Mr. Wood because it's certainly not my determination whether Mr. Wood is suffering from mental health issues. I have no idea whether you are, Mr. Wood. You're saying you're not, and that's fine. I'm not denying that either. I'm just saying that's not within my purview. Your attorney was so concerned with the communication that he filed the motion seeking, I think, additional help, a clarification from somebody that is an expert. But to the court, that's not that's not an extreme circumstance, but it's one that causes a significant delay. And I'd rather not have that delay if I'm not sure that it's needed. Through my discussion with you today, I'm pretty clearly convinced that if you are patient and if you take the time to listen, and if Mr. Horowitz is patient, and he's always appeared to me to be a patient attorney when given the opportunity, I think that what you'll be able to do is communicate with him and tell him what you want to do, and he'll be able to tell you what he thinks you should do as an attorney. That's what he needs to do, is give you legal advice. But that two-way communication street can't work if either one of you isn't willing. Mr. Horowitz, given what the court has gone through so far and elicited from Mr. Wood, are you willing to try and communicate with him in the future about what is needed?
Of course, Your Honor, absolutely. And I have been sending pretty much all of the communications by mail as well. So plea offers have been communicated by mouth and by mail. And then when I was unable to explain the guidelines.
Gentlemen, I know that there's other cases. I recognize that, but you can handle the other cases outside of the court hearing, because even Mr. Horowitz is trying to find out if this has something to do with this case. So wait until we have a break. If you need a break, I'll give you one. Then we'll come back to Mr. Wood. Go ahead.
Judge, I was saying, even after the last meeting, when I had been able to explain the guidelines on his charges as charged, I was not able to explain the guidelines as what would follow from the plea offer. I followed that meeting with a letter containing that information. So I have been able to communicate, at least by writing, although for whatever reason, Mr. Wood is indicating he's not getting those communications.
So Mr. Wood, have you gotten any written communications that your attorney has suggested he sent?
I got one yesterday.
Okay. Are you able to read and write and effectively communicate that way? And I'm not asking to try to embarrass you, but some people are able to communicate easier just by talking back and forth than trying to do it over writing. Do you have a preference on what you think would be easier for you to understand in writing or in person, or in the phone, over the phone or Zoom? Okay. All right, anything further, Mr. Horowitz?
Two things, just for your Honor's consideration. The characterization that I only want to speak about the time he is looking at, I feel it necessary to say that my description of that time was an answer to a direct question from Mr. Wood. When I was explaining plea offer, Mr. Wood directly asked, "What is the time I'm looking at?" And I answered that question. So it was not a preoccupation of mine. It was me candidly answering a direct question. And then additionally, my understanding is, and I don't have the records and I don't know what, but my understanding is that either the jail or CMH has been under the belief that Mr. Wood needs some sort of mental health medication that he is in fact refusing. I don't know what it is. I don't know if he needs it, and I'm not a psychiatrist or doctor, but that I'm aware that that's what Mr. Wood has told me. And Mr. Wood does not trust the facility to administer the medicine and believes that they are trying to give him something that will affect him adversely.
Mr. Wood, I hope you can sense, I'll tell you what I can sense, and I'm just going to offer to you. I hope you can sense it as well. I think Mr. Horowitz feels like he's in a very difficult position. He has several different duties. One, he has a duty to the court to make sure I'm aware of certain things. Even though he's your attorney and only your attorney, his duty of candor means he has to be truthful to the court about things. He also is very limited in what he can mention to me. And that's why in the things that he told me in this written motion, his only concern is that you're not understanding. And if it's his way of presenting it, he wants to see if there's other issues going on. But I hope you can also tell that Mr. Horowitz is trying hard, at least from what I can tell, to not betray any type of other confidences. He hasn't brought up once any of the things about the underlying case in front of the court, and he shouldn't, but he knows that and he hasn't. So I hope you can understand that your attorney is trying to walk a delicate line to make sure whether or not you need help with mental health concerns or not. You're saying you don't. He's expressing that he has concerns about it. I'm going to deny the motion for a competency evaluation currently, because you've convinced me, at least now, Mr. Ward, that there's not a need for that right now. You appear to understand what you're facing. But I'm going to direct and require that you and Mr. Horowitz have further communications, because ultimately, if the communications end with you swearing at Mr. Horowitz and leaving, or him swearing at you and leaving, there won't be able to be any effective communication at all. So I'm going to hope that you can get back on track with effective communication. Mr. Horowitz, if you need to re-raise the issue, you can do it in writing again if you want to, or bring it up orally. But at the present time, I'm going to continue this matter for a month. I'm going to give time for Mr. Wood to communicate with you and see how we can proceed. Do you have any questions regarding the court's order, Mr. Horowitz?
No, crystal clear. Thank you, Judge.
Do you have any questions, Mr. Wood? No. Do you have anything further on behalf of the people?
No, Your Honor.
Good luck, Mr. Wood. Please communicate with your attorney, and Mr. Horowitz, please do the same.
I'll see what the justice will.
Court is on record then in the matter of People versus Ryan Dean Beck, file 25-5004 FH.
Ryan Ziegler on behalf of the people, Your Honor.
Thomas Seeger appearing with on behalf of Mr. Beck.
Mr. Beck, welcome. Are you Ryan Beck?
I am.
Okay, welcome, Mr. Beck. So we're here on a status conference today. Your attorney, the prosecutor, and myself, we're all here in the circuit court for Kalkaska County. As you know, we had this matter set for a final status conference and plea cutoff. And then if the matter is not resolved by way of a plea today, I was simply going to calendar for trial and the jury can determine the issues. Do you remember all that background?
I remember that.
And did you have enough time to discuss in advance of today's date with your attorney what it is you want to do?
For the discussion that I had with my attorney, I think it might be better if he answers that question.
Well, I'll certainly hear from your attorney, but ultimately you need to understand that I'm going to have the same question for you. Because while your attorney obviously knows the case, it's your matter. You are the one charged and facing the consequences. Therefore, you are the one who will make the decision. So I will take you up on your suggestion. I'm going to hear from your attorney, but bear in mind, I'm going to come back to you because I need to do so. Mr. Seeger.
Yeah, Your Honor. So yes, I don't think Mr. Beck is trying to be disingenuous in any way. I think he was just trying to defer, because the conversation that I had with him was, he had provided me with some names of witnesses that we had struggled to locate because they're not contained within the report. And these were people that were part and parcel of our defense, to the extent that we're able to see what they specifically may know or may not know, which we had been trying to figure out who these people were during the course of the case, which we weren't able to specifically pin them down because it was at somewhat of a festival type situation. So some of those people weren't specifically known, and it's not entirely clear whether or not they'll be able to give us some information. But in speaking with Mr. Beck recently, he was able to identify some people who he would like to have talked to, which he's attempted to talk to them. I've attempted to reach out to them. But I think that the only way that we're going to be able to resolve that would be if a professional investigator does that. We could still do that, Your Honor, within the time frame. If the court sets it for a trial, we will still have enough time to investigate that one way or another, if the court gives us the time to do it.
Why has the investigation not already been ongoing?
Because I need to find an investigator. This is something that he was able to pin down within like the last week or so. So I can't.
So the offense date was September of 2024. A week before April 21st of 2025, you first get a name of witnesses to try to identify that you can't identify by simply calling them, and now you need an investigator to identify them.
I need an investigator to ask them specifically, as I'm not going to call myself as a witness at trial one way or another. And I would prefer that an expert or an investigator look at those people and talk to them independently, so that if they have something that's meaningful for me to use, I don't have any objections to setting the matter for trial, because ultimately, if that's where we're going, that's fine.
Well, I don't think you're understanding my concerns, because I'm not asking if you have an objection to trial. I'm trying to get clear on this point. Were there things that needed to be done before today that affect whether or not I should treat this case as what I said it was going to be last month, which is a plea cutoff? Because if we need a trial, I'm just going to simply set a trial. I don't mind having trials, and I know that you don't either. But the question first is what you're actually asking for. So I'm sensing that what you're asking for is more time to consider the investigation and potential witnesses, but I haven't heard you say that.
Yes, Your Honor, I would prefer, to the extent that the court is willing to give us a brief adjournment to have a investigator look into the claims and witnesses that have been provided to me. That would be helpful to determine whether or not we're going forward with the trial. But I do also recognize that the court was gracious in the last go-around wherein it set this as the final settlement date. So to the extent that the court is unwilling to give us another final settlement conference, then we just need the time up until trial, and that's the way that we'll proceed. The prosecuting attorney has given Mr. Beck a favorable offer, which I have said to him, you can accept or you can decline. That offer would be a misdemeanor. At this time, Mr. Beck has asked whether or not he can look into these witnesses, which he was only recently able to identify, which if given an additional period of time, either one of two things will happen. Either his beliefs will be solidified and will proceed to trial and will call his witnesses, or in the alternative, if the court will give us one final jury status conference, if we're unable to verify some of his beliefs, then we would probably exact a plea.
Mr. Ziegler, did you wish to add input?
Your Honor, while I don't put a lot of stock in the defense is putting forward, it's an involuntary intoxication defense. I got notice of that on March 25th. I don't really have a lot of belief that the defense is going to procure witnesses to that effect. But if the investigator can either confirm or deny those claims, it would certainly help resolve the case one way or another. So to that end, Your Honor, he was arraigned back in December. The case was bound over in January. It's not so old that I don't think a 30-day adjournment would be reasonable in the circumstances.
Well, if I calendared the matter for trial and provided a 30-day window for last-minute plea negotiations, would that accomplish both of those goals?
I don't have any issue with that either. That's what the court wants to do.
Mr. Seeger, does that pose a problem for you?
Your Honor, I guess the only thing that I could say is the investigator is going to apportion whatever time the investigator can apportion, and then he will make a good faith effort to attempt to find these people. How long that will take, I can't specifically say. And because it's not up to me to do these things. That's why the investigator would do it.
Well, it certainly can be done by you. I understand what you've reported and you have a basis to report it, why you want to have witnesses interviewed, particularly because you don't want the potential that you would have to be called as a witness, which you know you can't do. But it's also completely within an attorney's job requirements and abilities to interview witnesses themselves. So I understand why you're seeking to do it one way. It looks like we lost Mr. Beck, and I'm hoping he'll pop back in. But here's the court's decision. This case is not so old that I have a ton of concerns about the timeliness of the request. But it is so old, especially in consultation, in combination with what we discussed last month, is you thought the case would be resolved, and Mr. Beck is just popping back in now. You thought the case would be resolved. I followed your suggestion by setting a final status conference and plea cutoff. I don't like the idea of last minute then things coming up, which could have come up months ago, which are now seeking to delay. But I also understand that sometimes what happens is defendants try to identify witnesses. It takes time, especially if the situation as you reported it, I have every reason to be reporting it accurately, with some sort of a festival. So in that way, I don't have a huge issue with pushing back a plea cutoff date in this particular case. I'm going to calendar the matter for trial. Mr. Beck, I'm going to set a status conference in 45 days. And that status conference in 45 days is more firmly going to be what I told you this is going to be. In other words, I'm not going to allow you to enter any plea after that 45-day time period. You have either done to identify whatever witnesses may be there, what you need to, or you haven't. But I've given you now enough time already by now. And with additional 45 days, it's more than enough time for you to be able to do whatever you need to do. If you don't want to take a plea offer, you don't have any problem with that. You don't have to consider plea offers and you're entitled to a trial. But I need to know for scheduling purposes if that trial is actually necessary. Mr. Ziegler, if we have a trial, how many days will it take you to try?
Your Honor, I think generally speaking, it could be done in a day, although it may depend on if Mr. Seeger's investigator turns up some fruitful witnesses and what number they are, and we might need a second day.
Mr. Seeger, I know you don't really know who the witnesses are or what they'll say. Do you have any input though on the length of the trial?
Yeah, I would say probably at most it would probably be a day and a half. It's not like the type of trial where I suspect that we would have difficulty selecting a jury. It's just a question of how long this would take.
The court is going to set a one-day jury trial. I'm looking at the complaint and the information charges, malicious destruction of a building and disturbing the peace. I recognize there may be some other complicating factors that are identified or brought up if there's additional witnesses divulged by the defense. But so far, those witnesses are not divulged, and we don't know if they're even going to be located, let alone going to be provided testimony. There are 2 listed witnesses on the prosecution's information. And while there might be more, I don't expect we're going to need more than a day. So I'm going to set a one-day jury trial. If and to the extent, Mr. Seeger, your investigator has brought up more witnesses at the final status conference and plea cutoff in 45 days, you can let me know that. And if you can convince me that there's a need for more than one day, we'll take it up at that time. Mr. Beck, do you have any questions regarding any of that?
I do not, Your Honor.
Anything further, Mr. Seeger?
No, Your Honor.
Okay. All right, you're all set. Thank you.
Thank you.
People of the State of Michigan versus Brandon Lee Thomas, file number 24-7175 FH, time and date set for sentencing. The defendant is present, represented by attorney Michelle R. Siv. People are represented by Assistant Prosecuting Attorney Alexander Pani. On February 24th of this year, the defendant had pled guilty to aggravated stalking. Mr. Nathan Licht has prepared the pre-sentence report dated March 21, 2025. Ms. Siv, have you and your client had the opportunity to review the pre-sentence?
Yes, we have.
Are there any additions, deletions, corrections, or objections to the report other than guidelines?
In regards to objections or corrections, I'm not sure I was comfortable about it, but on the very first page under substance use history, it's indicated yes, that there has been. In regards to use of alcohol, Mr. Thomas decided that he first tried alcohol at a young age, at 13 or 14. However, there's never been any issue with use. So we're supposed to have that stricken from the report. And the same thing with THC, there is use, but there's no indication of use. So,
Noted substance abuse plan, we input that stuff into cons, generates on the first page, even though I admire no abuse on it. Yeah, but I've got it outlined in my substance abuse narrative, what he reported.
If you could add to the report then that the defendant denies any substance abuse. That'd be noted. Does have anything else regarding the report?
no, you're right, that was it.
All right, Mr. Thomas, is there anything else that your attorney didn't mention regarding the report? Honey, any objections to the report as well as guidelines?
No, Your Honor.
Any objections to the guidelines?
No, Your Honor.
What would you like to say on behalf of your client before the court imposes sentence?
I had a chance to go over the recommendation with Mr. Thomas. I asked the court to adopt most of the conditions with the exception of the jail time. 90 days recommended, but I would ask for the court to consider if there's a different way to go about that due to Mr. Thomas being, he owns his own lawn and snow care business. So in regards to his employment, that's the only way, that's the only income source. And he provides for himself and his family. He has 2 minor children who he cares for fully all on his own. The mother, unfortunately, is not involved. Does not have any contact with the children. So he is the only care provider as well for his minor children. And based on Mr. Thomas being employed and whatnot, I know in the report it does indicate that due to a memo that the court had sent out last year at some time in regards to the conviction of aggravated stalking that work period would not be allowed. On my client's behalf, I would ask the court to reconsider that and possibly allow Mr. Thomas to participate in work release while serving any jail time. I would ask the court to that if the court just wouldn't allow that, then that the possibility of Mr. Thomas serving time on weekends up till due to his work schedule, he could do weekends all the way up until the 1st of November. Then he wants to serve straight jail time if that court okay that. But I asked the court for that as well. While on bond, Mr. Thomas has not had any issues at all in regards to doing everything he's supposed to do. He has been doing everything he's to do. There have not been any violations, so I asked the court to consider that as well. He does not have any prior felony convictions, this unfortunately will be his first. But in regards to anything else, or again, I would strongly ask the court to consider a way that Mr. Thomas can continue his employment. He does have contracts that are signed with, companies in a lot of residential areas in regards to him needing to perform services for them. If he does not do so, then contract. All Mr. Thomas really wants to do is take accountability for what has occurred, but also stand for his family. They are number one. So I would ask the board to consider all of that as far as hopefully maybe coming up with something so that way he is still able to provide for his family himself. Yeah.
Mr. Lake is prohibited by a statute, right, regarding work release.
I don't think it was statute. I think it was
The memo, the court. Okay. Okay, thank you. Does your client wish to address the court, Ms. Sick?
No, it was no conscious.
All right, thank you. Mr. Kahane, anything to be happy?
Yes, Your Honor. I would note, just for the record, that the complaining witness is not present in court today because she is terrified of this defendant, Your Honor. There is no safe place in Huron County for her because, as the court may recall from the factual basis placed at the no contest plea, the final incident that resulted in Mr. Thomas's arrest by the Bad Axe Police Department occurred in this very building. So she doesn't even feel safe coming here to speak to the court directly about the effect that his behavior has had on her over this course of stalking. Now, Your Honor, that's a word that gets thrown around a lot, stalking, it's stalkers, but in this particular case, it fits the bill perfectly. What this defendant did to his ex-wife is disturbing at best. As soon as she filed for divorce from him, he immediately on the same day goes and files a mentally ill petition in the probate court, has her picked up by the police and taken to Sure Hospital for a mental evaluation because he just can't believe that she's filed for divorce from him. She's immediately cleared from Sure Hospital, but that's not where it ends, Your Honor. She wonders why everywhere she seems to go in Huron County when she's out and about with her friends, carrying on her normal daily activities, he seems to show up. And she can't figure it out until, at one point, she takes her car to a mechanic for service, and he finds a GPS tracking device installed in the vehicle. Now, he's indicated to the police that he puts that on all of his snow removal equipment and all of his vehicles, and it turns out that it had been installed on her vehicle for years. It hadn't been activated until such time as she filed for divorce, and he reactivated the account so he could know exactly where she was. And Your Honor, we're not talking about an Apple AirTag or something that one puts into a vehicle. We're talking about a hardwired device that was wired into the vehicle's power so he could know where she was at all times. And that's how he knew how to show up wherever she was, whatever she was doing. There was Mr. Thomas, a true stalker in the very definition of the statute. Your Honor, the recommendation from the Department of Corrections in this case is appropriate. Mr. Thomas does need to go to jail for 90 days, and he does need to be supervised for 5 years because his activities indicate that this breakup is something that he can just not get over. And the people are frightened as to what he might do if he is not on constant supervision. But the 90 days in jail, Your Honor, are going to be a wake-up call for Mr. Thomas in that when somebody breaks up and a relationship ends, that means it's over. And you can't just keep pushing for it. This is appropriate, Your Honor, and we ask for the court to institute it as written.
Does have any other?
Your Honor.
Sorry?
She is.
Oh,
And based on what I've heard, I would like to say something.
please come forward, miss. I didn't see you back there. I apologize. I'm right over here. Your Honor, this is Danielle Slater for the record.
Ms. Slater, go ahead.
I really am not comfortable doing this, but based on the fact that this man comes here and lies every single time we are here, this has not stopped. But it's things that the police cannot do anything about because he's going to other people. My boyfriend is here. Mr. Thomas aggressively confronted him in a gas station parking lot, threatening to get him banned from the premises. He went to my coworker's other job when my coworker wasn't even there, and when he went there for work the next time, everybody in the building knew who I was. They all knew that he was my ex-husband. They all knew all of this
information about me, and he was allegedly there for a birthday party. He tried to make contact with my mother, my sister, my cousin, my best friend's husband, because he knew that I was at her house. He watched me pull down into the road she lives on. There's 3 houses on this road. And hours later, he's sending her husband a friend request on Facebook. All within the last couple of months. 2 weeks ago, he followed me home from Caro, pulling a trailer. Instead of, I'm going 45 mile an hour, trying to drive carefully. Instead of doing the speed limit and going around me and going on about his day, he hung back, following me. This has not stopped at all, and these are just the things that I have caught him doing. This is not going to stop. I came here last summer during one of the numerous hearings he called to terminate my PPO because he just wasn't doing anything wrong. I told you that he was publicly going around telling people that he would not stop until a judge made him, and I am asking you, please make him stop. Because this is not gonna end. He could go to jail for full max sentence and have 10 years of probation, and I almost guaranteed you will be on my doorstep the day that he is free and clear. This has not stopped at all.
Are there any children in common?
No.
Okay.
And I honestly have sent my son to live with his father. And I'm really not even comfortable with that because he has numerous times tried to take my child from me. It's not even his kid.
Anything else?
No.
Thank you.
Thank you.
Your Honor, with that in mind then, and I apologize to the court for representing that Ms. Slater wasn't here. I didn't see her go into the back of the courtroom. But with that in mind, Your Honor, I would mention that Ms. Slater has made those reports that she mentioned to the court, to the pretrial services officer about Mr. Thomas appearing in other locations, having a confrontation with her boyfriend in the city of Cass City. Those reports were made to law enforcement and turned over to the pretrial services officer. But again, law enforcement's hands are tied because he's not making direct or indirect contact with her in their estimation, but it continues. And it's not going to stop until this court makes it stop.
Let's see if any other.
Just in regards to Thomas's comment, I think that his behavior on bond, well, that he is doing these things, not contacting her. I think a lot of the things that were mentioned were very speculative in regards to what he may or may not do at the end of all of this. As court is aware, I mean, there were issues with having that PPO in place for both sides, even on the victim side as well. She was doing things that would contradict in regards to what was in the PPO, and there was actually a hearing on it, and the court somewhat basically ordered them to just stop and knock it off. So that was towards her as well, it wasn't just towards my client. So I was responsible for that too.
All right, thank you. Defendant has no prior felony record. He has 5 prior misdemeanors, age 42. Gainfully employed, doing his own work, which is admirable. And was in a relationship, married to someone where it just didn't work out. And if it doesn't work out, especially if there are no children in common, the whole idea is to go their separate ways, move on from it, learn from it. That's the end of it. That's not what happened here. The court does recall the PPO that this court authorized and the hearings that we've had subsequent to that. And the whole idea was there's a valid order in place, just stay away. That's what it comes down to. Now, the court is not aware of any alleged contact over the last couple of months. If it was reported to pretrial services, it wasn't reported to the court. But the court can certainly consider that as well. But at the end of the day, again, I'm not making light of this, but remember the old song, well, it's old now, I guess, Disney theme, let it go. Absolutely. Let it go. There is no relationship anymore. There's no contact. There's no nothing. You see her, you walk away. And that's what you have to do moving forward. Now, what is troubling to this court is it's one thing to show up and maybe track someone on their iPhone, or friends are saying, hey, look, she walked into the bar, or he walked into the bar, whatever the case may be. But you took the approach of actually installing a GPS device on the vehicle, which again is unheard of, frankly.
Your Honor.
That's
Your Honor, I apologize. In regards to that tracker, just so the court is aware, the device was previously on the vehicle beforehand. It was just reactivated.
what, and I'll accept that, but reactivating it is the issue.
Your Honor, I would note that Ms. Slater informed the police agencies that she changed vehicles during the course of this tracker having been purchased and installed in the vehicle. She owned a different vehicle at the beginning of their marriage where it was installed. Then she purchased a new vehicle over the course of their marriage where it was removed from the previous vehicle and reinstalled in the vehicle that it was found in. Just to clarify the record.
It doesn't matter the court. A GPS device is a GPS device, and it was utilized, and which caused the problem. And clearly, we have a victim in this courtroom that is terrified of this individual. That's just the way it is. And it comes down to, again, let it go. Walk away from it. Considering the defendant's history, considering all the factors in this case, it will be the sentence. This court that the defendant be placed under a mandatory term of probation for a period of 5 years. It's required under law. 5 years probation. Conditions of probation include the standard conditions: not to violate any criminal law of any government, not to leave the state of Michigan without prior approval of the court, notifying the probation agent at least monthly or such times and places the agent may require, no alcoholic beverages consumed or possessed, nor enter bars or where the primary purpose is to serve alcohol for consumption on the premises, comply with requirements of alcohol and drug testing and following all the directives, no use of or possession of controlled substances unless prescribed by a licensed physician. Can't be around anyone that possesses those items or possesses drug paraphernalia. You cannot possess drug paraphernalia. You are to complete any mental health, domestic violence, battery intervention, or other recommended treatment following assessment by a qualified community-based service provider, waive confidentiality to allow any treatment program required to attend and disclose the information to the agent. You are to comply with the DOC's electronic monitoring program as directed by the agent. Here's the significant one: no verbal, written, electronic, physical contact with Danielle Nicole Slater, either directly or through another person. So you can't channel through a neighbor, a friend, anyone. No contact, nor are you to be within 500 feet of her residence, school, or place of employment. No assault of abusive, threatening, or intimidating behavior. No verbal, written, electronic, or physical contact with anyone housed within an MDOC facility. Nor are you to have the same type of communication with anyone engaging in a behavior that constitutes a violation of any criminal law of any unit of government. You are not to use any object as a weapon, nor own, use, or have any control or area control a weapon of any type. You can't even possess an imitation. You are not to be around anyone that possesses those items. You are to allow the agent to your residence at any time for probation supervision, where you are subject to a search of your person and property, including but not limited to your vehicle, residence, or computer, without the need of a warrant if the agent has reasonable cause you have items that violate the terms of your probation. Crime victims assessment of $130 will be ordered. Probation supervision fee $30 per month, regular, $60 electronic. A fine of $500 will be ordered, payable at the rate of $10 a month. Attorney fees in the amount of $400, payable at the rate of $10 a month. DNA testing fee of $60, $68 is the state cost. Probation is authorized and empowered under statute to effect your apprehension, detention, or confinement of up to 72 hours on reasonable cause you violated the terms of your probation. If referred, you are to successfully complete any PA 511 programming based upon eligibility. Finally, regarding the jail time in this matter, the guidelines in this matter are 0 to 9 months. The court has to consider the guidelines. The court will sentence the defendant to serve 270 days in the county jail, credit for 2 days previously served. The first 90 days minus the 2 must be served up front. The remaining jail time will be held in abeyance pending successful completion of probation. Regarding work release in this matter, I cannot carve an exception out in this circumstance. I'm sorry, but the court has to follow and stay consistent, no matter who you are or where you come from. Work release is not authorized in this matter. However, PA 511 programming otherwise is. Bottom line, Mr. Thomas, the old phrase, lose the number, no more, stay away. It's my duty to inform you of the right to seek leave to appeal. If you're financially unable to provide counsel of your own choice, the court will assign counsel for you at public expense. Please initial the receipt and questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 14 days. Remain in custody of the sheriff. That'll be all. Thank you. People of the state of Michigan versus Daniel Kent Velasco. Excuse me. File number 24 7201 FH. Time and date set for sentencing. The defendant is present. Represented by attorney Andrew R. Lockard. People are represented by prosecuting attorney Timothy J. Rakowski. The defendant back on February 18th of this year pled guilty to embezzlement by to a vulnerable adult, that is, $20,000 to $50,000. Ms. Karen Eberlin has prepared the pre-sentence report dated April 15th. Mr. Lockard, have you and your client had the opportunity to review the report?
We have.
Are there any additions, deletions, corrections, or objections to the report other than guidelines?
There are not.
Do you agree with that, sir?
Yes, sir.
Any objections scoring the guidelines?
No, Your Honor.
Do you agree with that as well?
Yes, sir.
Mr. Rakowski, any objection to the report as well as guidelines?
No, Your Honor.
Thank you. Mr. Lock, I'm sorry. Yes, Mr. Locker, is there anything you'd like to say on behalf of the defendant before the court imposes sentence?
Yes, Your Honor. Thank you. Mr. Velasco, it's been a pleasure to work with during this case as far as been very pleasant and kind of time during this case. Very never looked as though, never felt hiding or trying to wiggle around things. And I think that kind of how he explained matters to me is not only very plausible, but I think very mitigating as far as what the recommendation should be in this case. You know, this is something that happened with regarding his son about 10 years ago. I think much of what happened wasn't necessarily any sort of absolute desire to victimize the son, but it was just a situation where, you know, the knowledge and the ability to make records, keep those records and kind of sort things out between what's his son's, etc., was where things kind of fell into a gap with him, just as far as understanding fiduciary duties, responsibilities, things of that nature. But there wasn't any, 10-year desire to victimize his son. I would note that this is his first offense. He is just over 60 years of age. He's not a career criminal. He's not has any sort of history, or he's shown through those 60 years that this is not the person that he is.
Except this is exactly who he is. And for those of you, if you miss the charges, he is charged with taking advantage of a disabled adult under his care and basically exploiting his son by means of abusing his fiduciary responsibilities.
I believe that in light of not only his past history, this facts surrounding the offense that we're sentencing here today, as well as the fact that he is disabled, he's does have some medical issues that the court is not imposed the sentence that's being requested. I think that the 2-year probation is definitely adequate and appropriate. But I would ask the court either A, not to sentence him to jail time, or that any jail time be deferred pending his successful completion and abiding by the probation.
Very well. Thank you. Mr. Velasco, is there anything you'd like to say? Oh, I'm sorry, this is a no contest plea. So does your client wish to address the court?
He does not hear.
Very well. Mr. Rakowski, anything on behalf of the people? This is a victim's rights.
It is a victim's rights case, Your Honor. The victim is present in the courtroom, but asked me to read a letter to the court. Your Honor, I, Anthony, am here today as a victim to speak about the devastating emotional and mental impact that my parents' embezzlement has had on my life and will continue to impose on my future. This crime has not only caused a significant financial loss for me, but has also left me with a deep sense of betrayal and a profound loss in trust. According to my parents, not even considered one of their children anymore due to this case. I've received numerous text messages and there have been multiple Facebook postings toward me which were quite hurtful, including wishing death upon my unborn child when the pregnancy was announced. Eventually, my fiance went into early labor and our son passed away. When we went to the hospital, my father called, not to offer condolences, but to make statements unrelated to the deep loss we were going through. They have shown no remorse and continue to disregard any wrongdoing on their behalf. Even though my parents, Daniel and Carrie, are co-defendants, I feel as if my father holds more responsibility over the financial aspect as he had complete control over the finances in the household for years. My mother may have known what was happening, but I feel strongly that she wasn't involved in the transfer of money between various accounts, spending it recklessly and applying for, receiving, and charging up multiple credit cards using my name and personal information. I have experienced and have been left with thousands and thousands of unforeseen debt on my credit report. It is difficult to apply and be approved for a loan with these existing balances, which have gone to collections. After all, I'm requesting that my mother not receive jail time or a minimal sentence and only be held responsible for not speaking up in the situation. I'm also asking my dad hold the majority of the responsibility for this crime due to the financial aspects and having him complete control over not only me, but my siblings when they were younger, as well as my mom with his manipulation and scoundrel ways. So we ask you to take into account what the victim has said in this case. Would point out to the court, Mr. Lockhart says that Mr. Velasco doesn't have a criminal record. Well, that might be the case. However, as the report points out, and I agree with the Department of Corrections in their analysis of this, as they write in here about the negatives of this case, it says it doesn't appear as though they were looking out for Anthony's best interests into this consideration. It appears that they may have had financial and credit issues and used Anthony's guardianship to benefit themselves, their needs at the time, instead of Anthony's best interests. And it further goes on to say that defendant's Social Security disability income is $941 a month. However, at this time, at the interview, it was this writer's understanding that the defendant's income all goes to rent. So restitution is a big issue in this case, Your Honor. The restitution amount that has been requested, $224,736.67, which is a lot. And as Ms. Eberlein points out in her report, and I think it's bore out by the investigation, you have Mr. Velasco and his wife applying for credit cards. They bought a house. They bought a car in their son's name, and all to his detriment, because as he's indicated in his letter, I got this mountain of debt. It follows me around when you try to apply for anything, try to get a car, try to get a house. He's always going to be encumbered by that until that obligation is taken care of. And it appears from the information here that that's not something that will be able to be done. There were tools. I think it was a Harbor Freight credit card that was opened up with Synchrony Bank or whatever. And when my understanding, at least through the investigation, when they requested Mr. Velasco about selling these tools off to make good on at least that part of the debt, he didn't decide that he wanted to do that. And I think that's telling. The request of no jail time, I mean, what is the sanction in this case? That he's on probation for 2 years? I don't think that under the scenario with the money that is been reported through the investigation, that it comes close to what should be done. We would ask the court 5 days. I believe that's allowable under the guidelines. If for some reason there's some health issues, there is Dwayne Waters Hospital, State Hospital, with the prison system, and they could tend to his needs if that needs to be the case.
Very well, thank you. Mr. Lockhart, any other comments?
No, Your Honor.
All right, thank you. Mr. Velasco comes before the court with no prior record to speak of. He's just over the age of 60. and he's currently on disability at this point. And the court reviewed the pre-sentence report of this matter. To me, I guess it's a classic example of robbing Pete to pay Paul, is what happened. And to the tune of over $224,000, which to me, and to the court obviously is an astronomical number. It has to be addressed. I seriously question whether or not the restitution can be paid based upon the defendant's current condition. However, the court's certainly going to try to do so as this matter proceeds forward. There's no excuse or justification for this crime, period. Will be the sentence of this court. Going to be placed on a term of probation for a period of 2 years. Conditions of probation include the standard conditions: not to violate any criminal law of any unit of government, not to leave the state of Michigan without prior approval of the court, notifying the probation agent at least monthly or such times and places the agent may require, completing the Thinking Matters program to waive confidentiality and allow any treatment program that the defendant is required to attend to disclose that information to the agent, not to engage in any assaultive, abusive, threatening, or intimidating behavior, not to have any verbal, written, electronic, or physical contact with anyone housed within an MDOC facility without permission of the agent, nor to have the same type of communication with anyone that's engaging in a behavior that constitutes a violation of any criminal law of any unit of government. The defendant may not use any object as a weapon, nor own, use, or have under his control or area control a weapon of any type, not even an imitation. He is not to be in the company of anyone that possesses those items. He's to contact the supervising field agent no later than the first business day following placement on probation or release from jail. He's to allow the agent into his residence at any time for probation supervision, where he's subject to a search of his person and property, including but not limited to his vehicle, residence, or computer, without the need of a warrant if the agent has reasonable cause the defendant has items that violate the terms of his probation. Any arrests or reports, any police contact, loss of employment, change of residence must be reported to the agent no later than 24 hours from contact. Restitution to Anthony Velasco in the amount of $224,736.67. He's to execute a wage assignment to pay that restitution if he's working and misses 2 regularly scheduled payments. Crime victims assessment of $130 will be ordered. Probation supervision fee $30 per month regular, $60 electronic per month. Attorney fees are waived in this matter. I'd rather address the restitution than anything else. DNA testing fee of $60 will be ordered, $68 in state cost. The probation department is authorized under statute to effect the apprehension, detention, and confinement of the defendant of up to 72 hours on reasonable cause he's violated the terms of his probation order. If referred, he's to successfully complete the PA 511 programming based upon eligibility. Finally, the defendant shall serve 365 days in the county jail with no credit for time served. It's my duty to inform the defendant he has right to seek leave to appeal if he's financially unable to provide counsel with his close court will assign counsel for the public expense. He's to initial the receipt and questionnaire form requesting the assignment of counsel, both of which must be executed under oath and filed with the clerk of the court within 22 days. Manage custody of the sheriff. That'll be all. Thank you. Off the record.
There we go. He serves 1 year in jail and 2 years probation. Thought for a second he was getting away with it, huh? Yeah, $225,000 that he charged up in his son's name, his disabled son, an innocent person that he was supposed to protect, that he was supposed to love. I mean, my goodness. Like, how do you spend that much money? Plus, he had to have money of his own coming in. I mean, that's just what he charged and exploited. He also would have been spending the monthly Social Security checks. It's just mind-boggling, astronomical. how much he ruined his son's life for money. And then the comment about his grandchild, wishing death upon his grandchild, and then it actually dies. Oh my God, what a horrible human being. Yeah. I mean, there's that. There's always that. Maybe I know one thing he didn't buy. He didn't get himself a drunk man's words or a sober man's thoughts mug. Yeah, based on the kind of human that he has proven himself to be, despite his lawyer's assertions that he's not this kind of person, when he's exactly this kind of person, I have little faith that he's not faking it. That he absolutely has the type of personality of someone who would. To get onto disability for an easy paycheck, fake his disability. I've very little doubt that isn't what's going on. Yeah. Hi. What are you doing? Does that foot taste good? Yum yums on the foots? What are you doing, goof? Hi. You want to come say goodnight with me? Hi, Bandit. This is as close as Ava's getting. She does not want to come any closer. The bed's mighty comfy, I suppose. Thanks a bunch for coming. Once you finally realized. Yes, thank you guys so much for being here. All right. And needless to say, I'm not going to be doing an 11:45 stream because, this was my content. But I do appreciate everyone being here. Oh, they're going in the Nutcracker. They are going to crush. Oh, Mortimer Duke, I love you so much. Hi, baby. Hi. Oh, my pretty girl. My pretty bandit. Come here. Come here, bandit. We gotta show everybody how beautiful you are. Aww. Can we show them your front? Can we show them your beautiful face? Oh. She's like, no, let me free. Give me treats. Oh, it's such a pretty girl. Such a pretty girl. I just love her colors. I love her tortoiseshell colors and her sort of raccoonish tail. She's such an angel. Are you gonna come say goodnight with me? Well, her tail will say goodnight. It's waving. All right, guys. Be safe, be well, sleep sweet, and much love.